Yes, Mr. President.
May it please the court, for the record, I'm MS Mpatlele SC. I appear for the first appellant in the matter, together with my junior, Mr. Ndabel.
Thank you, Mr. Mpatlele.
May it please the court, justices, I'm here for the second appellant in this matter, together with my learned friends, Mr. Masuki, Ms. Olga, Mr. Terezi, and Mr. Tulu, as the witnesses.
Okay, Mr. Mpofu.
Justice Mbuza, members of the Supreme Court of Appeal, I appear for the Democratic Alliance, the first respondent in these appeals, together with Mr. Bishop and Mr. Willifair. As the court pleases.
Thank you, Mr. Ismail.
Justices, may it please the court, I appear on behalf of the Helen Suzman Foundation, together with my learned friends, Mr. Kutsudas, Ms. Trabella Polisi, and Ms. Crayer.
Okay, Mr. Duplessis.
May it please the court, justices, I appear for the third respondent, together with my learned friend, Ms. Fraser.
Thank you, Ms. Telabisakaki.
May it please the court, I appear for the amicus curiae together with my learned junior, Ms. Abdon.
Thank you. Mr. Mpatlele, you may start. I think you'll have to speak a little bit louder than you did when you introduced yourself, because the acoustics in this court are not that good. I hope you can hear me.
I can hear you.
All right, then.
Justice.
You may proceed.
Justices, I don't do, but there's an application by the amicus curiae. I would suggest that maybe the amicus curiae should firstly, I don't know whether it's...
Well, we dealt with that by way of a directive. She is already before us, admitted, and the direct practice directive have been issued. So I think we're good with that. We don't need to make another order that will give her audience.
Indeed so,
So
Justice.
you may just proceed.
As the court pleases. Firstly, I intend to deal with three issues. That is the issue of legality. And the second point that I intend to deal with would be one of relating to the medical reports.
Sorry, could you repeat that, the second point?
Medical reports.
Thank you.
And the third one would then be the remedy that has been imposed by the court accue, including that of substitution. Justices, I think the high water mark of this case, firstly, had to deal with whether the National Commissioner of Correctional Services had the power to consider and determine medical parole in respect of the second appellate. If the power lies with the National Commissioner, and I'll deal with the submissions of the respondent in terms of, where we differ, because to a certain extent we agree that the National Commissioner is empowered by Section 79.
Yeah.
Yes.
I think isn't the finer detail that the source of the power rather than whether he had power at all.
Yes. And for that...
Isn't the real issue whether he exercised that power regularly or not?
The first issue...
In other words, the question isn't whether he has the power. Mm-hmm. The Act says that he does in respect of certain categories of prisoner. And here, the question is really whether he exercised the power properly, in accordance with the law.
That's another leg of it. The first leg is, which is presented by the Democratic Alliance and the Helen Suzman Foundation, is that the National Commissioner does not have the power to determine the material conditions that are mentioned in Section 79 1A. They say he can only deal with Section he has the power to determine what is in section 79, 1B and C. They say he does not have the power to determine.
I think let's start with the Commissioner's case as you want to present it.
Correct.
Your submissions, before you juxtapose them to the submissions that are made by the respondent or
Correct,
on behalf of the respondent. And as I understand you, the issue is whether the power was exercised properly under Section 75(7) or that should have been together with Section 79.
Yes. Let me deal with that, Justice Thomas. Firstly, our submission is that the National Commissioner has the power to determine medical parole in respect of all the issues that are in Section 79, 1A, B, and C. And for that, the DAA has considered that the power lies with the National Commissioner, and has also, in their heads of argument on page 8, also considered that the National Commissioner's power to grant medical parole is subject to substantive constraint prescribed in Section 79(1). In other words, the National Commissioner can grant medical parole to a sentenced offender, provided all the requirements are met of 79, 1A, B, and C, or are satisfied. So we agree with that. However, we differ with the Democratic Alliance that the application must be considered by a medical practitioner attached to a correctional facility.
Attached to?
To a correctional facility. We differ on that point. And I'll deal with that when I deal with the issue relating to the medical report.
Whether the parole can be considered by the medical practitioner?
Whether the application must be considered, by a medical practitioner attached to a correctional facility. Because the process is like this. The process is that there's an application that is done by a medical practitioner in respect of this matter. It can also be done by the applicant. It can also be done by any other person, right? But in this respect, it was done by a medical practitioner. And we submit that because the application was done by a medical practitioner, there is no need that there should be another medical report, or that the medical report itself should be submitted to a medical practitioner attached to a correctional facility.
So because the difference is being considered and submitted. Are you saying that the application can be considered by the medical practitioner as opposed to being submitted by the medical practitioner and not attached to the correctional facility?
The medical practitioner that is supposed to submit a medical report in terms of the Act is not a medical practitioner attached to a correctional facility. And the requirements relating to a medical practitioner attached to a correctional facility are the requirements that only relate to, or which are contained in the regulations and not in the Act. And I'll deal with what is the as the first supplement, do we interpret the provisions of Section 79? We say Section 79 makes no provision that the medical practitioner must be attached to a correctional facility. That's the point that I'm trying to make.
Do you rely there on the notion that if an application is submitted either by the applicant or the inmate or person on his or her behalf, that there is a requirement only in those circumstances that there is a further report?
That is correct.
Is that the thrust of the submission?
Indeed so, Judge Hussein.
Thank you.
Justice Hussein. That's the thrust of my submission.
Then,
that since this one, it has been submitted by a medical practitioner
So
and Dr. Mafa.
thank you.
So there's no need.
I'm just trying to understand the submission, because it seems to me that then you would be arguing that in this instance, the application made by Dr. Mafa was not made on behalf of the second appellant. Is that correct?
Indeed so.
So on whose behalf did he make the application?
The application was made by the medical practitioner.
On whose behalf?
On the behalf of the second.
All right. So the position of the first appellant, your client, is that Dr. Mafa did in fact make the application on behalf of this second appellant.
That is correct.
If that is the case, then is the Act not clear that there is a requirement that a further medical report be submitted?
A further medical report, Justice Posset, can be submitted by the medical parole and advisory report.
Okay.
It becomes an additional report as provided for in section 79(2).
All right.
It becomes an additional report.
So in this respect, you differ from your colleague, Mr. Poff, who argues that in fact the application was not made on behalf of, and therefore there's no requirement for an additional medical report. Am I correct?
That is correct.
I see. Thank you.
That is correct. Even the reasons provided by the national commissioners clearly states that the application was made in terms of section 75(7) and read with section 79(1). So that's why we yes.
But going back then to your submission, that I think what the respondents refer to is the evaluation portion of the application. The application was completed by Dr. Mafa.
Yes.
On behalf of Mr. Zuma.
Yes.
Right. And the same medical practitioner then completed the evaluation of the application. Isn't that a problem?
No, that is not.
Because if Dr. Mafa is the applicant on behalf of the offender, he can't evaluate his own application. I mean, on a practical level.
He can, in terms of section 79(2)(c). And let's look at what section 79(2)(c) says. And in this respect, it refers to that medical report by Dr. Mafa. It says the written medical report must include, among others, the provisions of a complete medical diagnosis and prognosis of the terminal illness or physical incapacity from which the sentenced offender suffers. Roman figure 2, a statement by the medical practitioner indicating whether the offender is so physically incapacitated as to limit daily activities or inmate self-care. And 3, reasons as to why the placement on medical parole should be considered. This is what's supposed to be contained in the medical report by Dr. Mafa.
That's not how we read the section of the statute. Shouldn't we consider what is said in 1A, in subsection 1? There's no dispute about the contents, the provisions. But in 2, if you look at 79(2)(a), it sets out the manner in which the application should be submitted. And 2B provides that the application shall not be, if the application lodged by a sentenced offender or a person acting on his or her behalf in accordance with paragraph A2 shall not be considered by the National Commissioner, the Correctional Supervision and Parole Board, or the Minister, as the case may be, if such application is not supported by a written medical report recommending placement on medical parole. Yes.
Correct. It shall not be considered if it is not supported by a medical report,
Yes.
a medical report.
Which medical report does that refer to? Is that the
one by Dr. Mafa?
Right. Is that the one the one contained in addendum in CB11?
Yes, because that's the application CB.
The evaluation.
Yes, that's the application that was submitted, and that's the application CB11.
Mm-hmm.
The application starts from
CB10.
CB10, and justices will see that when we look at CB11, the issue of the diagnosis and the prognosis there appears when one looks at CB11 there on the D. Is the offender suffering from a terminal disease or condition which is chronic? And it was responded to by Dr. Mafa. Says yes. Is progressive? Yes. Has deteriorated permanently, reached a irreversible state, said deteriorated significantly. So this is the medical report that we are talking about.
Oh, so he completes it there.
Yes.
As a correctional medical practitioner. That's what the form says.
That's what the form says. But this was completed by the medical practitioner of Mr. Zuma.
Yeah, that's what I would need clarity on.
As part of his application.
Yes.
Mm-hmm. And without this, his application couldn't have been considered.
Correct. Yes.
So what is the next step? The next step seems to be in the consideration of the application, now that it's got over that first hurdle, 79.3a. The Minister must establish a medical advisory board to provide an independent medical report to the National Commissioner, Correctional Supervision and Parole Board, or the Minister, as the case may be, in addition to the medical report referred to in subsection 2C.
Yeah. So what now the medical parole and advisory report do is that over and above that report, that medical report, it must also provide its own medical report.
Yes.
And it has done so. And that's the medical report which did not recommend placement on medical parole. So what we're saying is that both these reports must then serve before the National Commissioner. And the National Commissioner must consider it together with all the other reports in coming to a decision on whether, under the circumstances, medical parole should be granted or not. And he has done so. And there are two reports, medical reports, that recommended that Mr. Zuma be placed on parole. And the first one is the one of MAPA, and these are the reports of the doctors that has examined Mr. Zuma. And the second one is the one of Dr. Mphatso, who is also a member of the medical parole and advisory board. But now, so all this report must serve before the National Commissioner, since it is the National Commissioner who has the discretion to determine whether to grant medical parole or not. So after you consider them all, in particular that this too has recommended that Mr. Zuma be released on parole, then he exercises discretion in that regard, following that.
So when Dr. Mafa completes the application, he completes it both as an applicant and as a medical officer providing a report.
Yes, he completed it on behalf of the applicant and also as a medical practitioner.
When he's completing it on behalf of the applicant, he's an applicant. He is the applicant. Or as the applicant. He is in the stead of the applicant.
He's acting on behalf of the applicant. Because he's not the one that is applying for medical parole. He doesn't want to be released on medical parole. So he's applying on behalf of the applicant for the applicant to be released on medical parole.
Right.
And he can do that. He can do that in terms of section 79(2). A, Roman figure 1. He has the power to do that.
Now, if you're correct that the Commissioner has the discretion to decide between these conflicting medical reports, how do we know how he went about deciding when we can't see what exactly the underlying condition is? That's been blocked out by black cokie pen. So don't you have this problem that it is impossible for the Commissioner to justify his decision without us seeing the entire medical reports? We can't say that he's acted rationally or reasonably in coming to his decision.
Similarly, Justice Plaskett, it can be said that it cannot be said that he acted irrational if ever that information is known. So both ways.
But he has to justify his exercise of power.
I just want to refer to the reasons that were provided, that paragraph 30 of the reasons that were provided. That is on CB 43. Paragraph 13, the National Commissioner says the following: having considered all relevant information, I'm satisfied that Mr. Zuma meets the criteria of Section 79(1) to be placed on medical parole. I hereby approve his release on medical parole immediately on the following conditions, and impose those conditions. What he does is that he has looked into all those records. The records that were before him, the national, were not redacted. They were redacted for the purpose of the proceeding because the second appellant did not agree that that information be disclosed. But now,
there may be consequences for that decision. You can. He decided that he wanted to his medical records to be private, didn't want them disclosed. But then, as I say, the problem arises that, and this is one of the consequences of that decision, that it may be difficult for the Commissioner to justify his decision in the absence of saying, here is all the information before me, you can see for yourself that my decision was a reasonable one.
There's a report, there are two reports which says that, for instance, when it looks at the report of Dr. Mao, it's very clear, it says that Dr. Mao is suffering from a terminal illness or condition. So
what terminal illness?
Which is something that the parole board looks at also. It looks at it. And where it says that, then it is not for the court to say, well, that is not correct, unless the court could say and look into the reports and say, but when I look at the report, this is not correct. But he has looked in that, he has examined the patient, and he says he is suffering from terminal illness. And the parole board is not even saying that he is not.
The Commissioner doesn't say that. Where in the reasons does the Commissioner say that the second appellant suffers from terminal illness or physical incapacity? Because you look at the decision and the reasons, you don't see that.
He says he has satisfied the criteria in terms of Section 79(1), and that criteria in terms of Section 71(9)(1) relates to the issue of terminal illness.
No, but there's preconditions. There's 3 preconditions, and all 3 must be met before.
Indeed, it has been met because the issue of whether he's suffering from terminal illness or not is something that has been determined by 2 doctors, by Mafa and Pato. And on that one, based on that one, he has then looked into whether the second 79(1)(b) is about whether he will re-offend, And the third one is whether there are certain arrangements that have been made upon Mr. Zuma's release. So it cannot be said that he must, because the words on the report doesn't say he suffers from terminal illness, but it says he has complied with Section 79(1), that can be ignored. It has been stated there.
There is a difference, though, Mr. Mphahle, because the Act says it is the board that makes a recommendation to the parole board or to the commissioner. That, to me, seems to be different from the report that would have been made by Dr. Mafa. Dr. Mafa says this is what the applicant is. This is his medical condition. Sets it out, and therefore he applies for medical parole. And then the Act has made a special provision for a body that will evaluate that application and actually make a recommendation. So to me, the status of what the board does is not the same as the applicant on behalf of the applicant.
Justice Dambuza, what Justice has been saying is what is submitted by the respondent.
Well,
that's not what the Act is saying.
No, the Act says written medical.
The only time it deals with the recommendation, the Act, is on Section 79(3)(a). I mean Section 79(3)(a). It doesn't say that the Act doesn't say that the board makes the recommendation. It says a minister must establish a medical advisory board to provide an independent medical report to the National Commissioner. So what it does, it must provide an independent report to the National Commissioner. And then it says that as the case may be, in addition to the medical report referred to in 2C. So it's an additional report that is provided by the medical parole and advisory board. It is not the report that determines whether the offender should be granted medical parole or not. It's an additional report that gives a new perspective to this application that is supposed to be before the medical parole and advisory.
So essentially, the Act as it stands now provides nothing different from, on your argument, from what it was pre the amendment in 2011, 2012. Because prior to that, a medical practitioner could make a recommendation directly for medical parole. And the amendment was brought into place, setting up the parole board as a body which seemed to me that would then evaluate the application, including the medical report that would be accompanying it. So on your argument, that's not the case.
That's the submissions by the respondents. That's the respondents that are making those submissions. Well, that is
a question I'm asking from you. It's not.
No, it is not.
Is it not?
It is not, because Section 79, when it was amended, it was to deal with the fact that initially a person could be released on medical parole when he was in the last stage of his illness.
Yeah, but
and it was intended to deal with that.
As to the medical examinations and what would support
there's no change.
Will you please, please, as to what would be the basis for the factual finding of either call it terminal illness or physical incapacity? Prior to the amendment, it could be made, the factual finding could be made by one practitioner. And the amendment came into place, it seems to me, that the medical parole board was set up to beef up the position as it was prior to it being put in place.
That is not correct.
Right.
That is not correct.
Yes.
If that was correct, then we wouldn't be having the provision of Section 79(2)(a) Roman figure one, which still grants a medical practitioner
Right. So,
the right, I mean, the right to bring that up, the application for me. It would have deleted that. And secondly, it wouldn't have stated explicitly that it is the Medical Parole and Advisory Board that has the power to recommend medical parole. It doesn't say that.
yeah, but what I'm putting it to you is that the position is the same now. The commissioner can consider the medical report by the one doctor or prefer one over the medical parole board report.
It doesn't have to prefer that, he has to consider them all, including the one of the medical parole.
Well, you can
advisor.
prefer after consideration, Mr. Mpahlele.
The-
And
in-
essentially,
indeed,
that would what
indeed, if he has reasons to do so, he can do that.
Absolutely.
Yes.
So where do we go then in the reasons at CB 42 and 43 to see how the medical reports were considered? Put aside the actual diagnosis of that would be the terminal illness. Where does the commissioner in the report say, I looked at these two reports that were presented before me, and this is how I went about to get to where I got to?
I just get an indulgence.
Sure.
Thanks for the indulgence, Justices. May I refer the court to CB 41? Paragraph 8. The National Commission says the following. The following documents were presented
Sorry,
to me.
paragraph?
Paragraph 8,
Oh, 8, okay.
CB 41. It starts there. The following documents were presented to me for consideration. 8.1. 3 medical reports by the South African Military Health Services dated 8 July 2021, 28 July 2021, and 5 August 2021. 8.2. A report by Dr. Mphatso and a member of the Medical Parole and Advisory Board commissioned to do a physical examination of Mr. Zuma and gathered evidence in support thereof. 8.3, recommendation by the MPAB on the condition of Mr. Zuma. All right? And then it then deals with the issue that impose the conditions where it's saying that on 12, I therefore requested that all relevant and available information be at my disposal for consideration as the legal authority to arrive at a decision. I inter alia considered the following in coming to the decision. All right? It says, Mr. Zuma is 79 years old and undeniable a frail and old person, that the various reports from South African Military Health Services all indicated that Mr. Zuma has multiple commodities which required him to secure specialized treatment outside the Department of Correctional Services, that Dr. L.J. Mphatso, a member of the board, in his report dated 23 August 2021, recommended that the applicant, Mr. J.G. Zuma, be released on medical parole because of his clinical health dictated health conditions, and that sufficient evidence has also arisen from a detailed clinical reports submitted by the treating specialist to support the above read recommendation. So from the reports that he had, it says that supports the recommendation of Dr. Mphatso.
Does it say anything about the medical parole board recommendation?
What?
Other than just stating what it says.
In paragraph 8.3, Justice, the recommendation by the medical parole on the condition of Mr. Zuma was also before the National Commission. So he has considered that. And then he came when he came. Yes.
I mean, I'm looking at how he evaluated the reports to get to his conclusion, because his decision is what is before us, or what was before the High Court for review. And in order for us to make that assessment, we have to work out or look at or consider how he went about evaluating the medical reports that were before him.
Perhaps could I add to that query?
If I may refer the court to paragraph 12.4.
Just wait.
Yes.
For the
sorry,
other.
I perhaps you didn't
Sorry,
hear me.
Justice Process.
I wasn't speaking loud enough. Could I perhaps just add to that question and take you back, if you like, in answering it, to the consequences of the redacted records that are before us? Is there not a principle that operates in these circumstances, that where a court is called upon to exercise its jurisdiction in determining whether a decision maker, or for that matter a court below, has correctly determined a matter, the absence of a record, of a full record, available to the court exercising its jurisdiction would generally result in the decision being set aside as a matter of principle? Does that not happen, for example, in appeals? If a court sits an appeal and there is no available record at all, and it cannot be reconstructed, and all it has is the judgment, would that not generally result in that being set aside?
Justice Wilson, it often happens, particularly in reviews, that if there's no record, that the decision is set aside. But in most cases, it's referred back to the decision maker, for the decision maker to consider that due to the fact that there was no record.
Well, no,
but yet there is a record.
It would still be set aside. The consequence may be that the matter is referred back. But yes. That's a remedial aspect.
Yes.
But if the court is unable, because of the lack of a record, to determine whether either a court below or an administrative decision maker has properly and correctly exercised the authority that he or she has, the court will generally set the decision aside and perhaps then refer the matter back. Is that not the difficulty that you face here?
My submission on that point, Justice Hossein, is that when we are faced, this is a situation where there is a report. It is not that there is no report at all. There is a report. The report is just that it is being redacted.
Yes, but that's the point. That's the problem. That's the point.
The record, my apologies, yes. The record has been redacted,
yes.
So there is a record. It's
no, one accepts that there is a record, but the court that is called upon to exercise its jurisdiction, in this case the court below, didn't have the material before it in order to decide that the authority was correctly exercised, and so too this court.
From my understanding of the judgment of the court, the court was of the view that on the information, all that information that was before it, including a redacted record, that it was in a position to determine the matter.
That is correct. The court may or may not have been correct in that decision. But this is a different point. The result is what is on appeal, the order that is on appeal. If that order is not justified, or cannot be justified because we don't have access to the record, is the result not that the appeal then cannot succeed? It can only be that one must look at the further remedial action that was imposed by the court below.
Just my submission would be that if the information, despite the medical reports being redacted is sufficient for this court to make a decision based on the point that we've submitted and the recommendations of the two doctors.
But the problem, if I can just come in, is that the information that has been scratched out with a Koki pen is the very information that goes to the heart of the decision that has to be taken. So how are we to know whether the jurisdictional fact, the first jurisdictional fact, is present if we can't see the reports? We have no idea, no way of knowing whether the Commissioner exercised his discretion properly. In other words, the problem looked at from the other side is that he has a great deal of difficulty in justifying his exercise of power. It's not good enough to say, trust me, I looked at everything and I took this decision and it's the correct decision. The review doesn't work that way.
The information is there. The information related, and I've pointed out in terms of what Dr. Mafa is saying, and also what is said by Dr. Mphat. Unless the court is saying we do not accept the reports of Dr. Mafa and the reports of Dr. Mphat. It is with that, then it says that we then have to determine as to whether those requirements have been satisfied. But there is a report that says that the person is terminally ill or is suffering from a terminal condition by doctor, is there. So there is information for the court to consider.
Well, the problem is that when even the reasons do not tell us the decision-making process as to how it was, how he went about it. For example, did he reject the board's recommendation, the medical parole board's recommendation? Was it rejected? For what reasons? What do we know? We're not deciding that he was right in the content of his decision. We're determining how he went about making this decision. Did he consider everything that was before him?
Indeed.
Where does it show that he considered it, apart from narrating that this is what I had before me? Where does he say that I rejected it or I didn't reject it or these are the reasons why I did? Did he prefer one over the other? What was happening? How do we know?
Justice Dabusa, may I just refer you to paragraph 12.4. He deals with the report of the medical parole and advisory board. He says in 12.4, the medical parole and advisory board recommendation agreed that Mr. Zuma suffered from multiple comorbidities. The MAPB further stated that his treatment has been optimized and his conditions have been brought under control because of the care that he is receiving from a special hospital. Therefore, they did not recommend medical parole. It is this type of specialized care that cannot be provided by the Department of Correctional Services in any office. He has looked into that and he says, but that is a clear indication that he has considered, he has rejected it.
Is that a criterion under the Act?
It's not. It's not. What he's saying is that he's rejecting.
Then how does that help?
It's rejecting it. It's rejecting it. The criteria is that it must be satisfied that the requirements of Section 79, 1A, B, and C have been complied with. And he goes in 13 and says that I'm satisfied.
In all of these reasons that he gives here, he says that Mr. Zuma suffers from comorbidities, he requires specialized treatment. That's as far as it goes. Nowhere does he say Mr. Zuma suffers from a terminal illness and therefore he qualifies.
it might not be said in explicit terms, but if one reads 13, one would understand that if one says he has satisfied the requirements of Section 79, it also talks about terminal illness, and 2, the issue of reoffending, 3, the issue of available accommodation. That's 79.
But in paragraph 12, where he gives his reasoning for how he arrived at his decision, there is not a mention of terminal illness, not a mention of the jurisdictional requirements of the section. And one would expect that and require that, surely.
It might be so, Justice Plaskett, it might be so. But my submission is that the whole report should be read in its totality. It must not be cherry-picked. It must be read in its totality. And if one goes back to 13, one would understand that 79 referred in paragraph 13 makes reference to the issue of the terminal illness without having to say it explicitly.
That's a conclusion that he draws from the reasons that preceded. And the reasons that preceded, as I've suggested, make no mention of a terminal illness. So how do we know that the conclusion is correct?
Because if one also look at the report of Dr. Mafa and Impak, they've dealt with that issue of terminal illness. So
Yes.
if this is a part of and that's why Rule 53 requires that there be a record.
Yes.
The intention of the record is just to put it before the court, for the court to look at the entire record. And amongst them is what is said. Yes.
And here the record deals with everything except the core issue, because that's all been crossed out.
I don't want to repeat myself on that point.
Yes.
I think I've belabored it
Yeah.
for quite too long. Yeah.
Sorry, Mr. Mpashele, all 3 reports, the decision, the reasons, as well as Mr. Mafa, Dr. Mafa and Dr. Patswe's reports, do not mention terminal illness and physical incapacity. So even those reports that you say have dealt with the issue, they don't categorically state it.
If I may refer, Justice, to CB11.
Yes, let's go to CB11.
Yes.
If you go to CB11,
And
4D,
paragraph D.
5D,
Yeah.
a question is categorically asked.
Yes.
Is the offender suffering from a terminal illness or condition which is chronic? Yes.
Yes.
Is progressive? Yes. Then the third one, the question is asked, has it deteriorated permanently or reached an irreversible state? The answer is not given as a yes or a no, but an explanation, deteriorated significantly. So there is no specific answer to that question. And
Can I
also,
Can I deal with that?
okay, before you deal with that, CB13, 6.1. It's asked again, or there's medical, functional, or physical incapacity. The only thing that says that's stated, medical incapacity. So there is no categoric statements that are made, even without really disclosing the actual prognosis. It actually doesn't tell that there is terminal illness, just those words, terminal illness or physical incapacity, such that the offender or the inmate is affected daily on their activities. So nothing, even if we go to these reports, they don't really help us that much.
Let me start with CB11. Firstly, this is an application form that in itself contain a medical report. And this is only what is required when an application for medical parole is done. They give you the form, you fill it as a medical practitioner. Now, there's a question that has been asked in D. It says, is the offender suffering from a terminal disease, and which is what terminal disease or condition, which is chronic? The answer is yes. It's an answer to the question whether it's terminal disease or condition. It's a yes. And then is it progressive? The answer is yes. Now, the third point, it says, has it deteriorated permanently or reached an irreversible state? Our submission on that point is that that is not required by the Act. This is a remnant of the past, just before the amendment of the 2011. It is not required by the Act because the Act does not require that, and I can read Section 79, it doesn't say that after all, that condition should have deteriorated permanently or reach an irreversible state. It doesn't require that. And the definition, if one looks at the definition, that would accord with my submission when I'm saying this is a remnant of the past, because in the past, before the amendment of Section 71, the medical parole could only be granted in the last stages of one's illness. And that becomes very clear from what is stated there, that this is a form of a remnant of the previous, before the amendment, because it says a terminal disease or condition is a condition or illness which is irreversible with poor prognosis and irremediable by available medical treatment, but requires continuous palliative care and will lead to imminent death within a reasonable time. There's no such.
Well, isn't it that the whole of CB11 is in effect not a requirement of the Act on your argument? This is a Regulation 29A3 form, essentially. It's not a requirement of the Act on your own argument.
The regulation doesn't say that the disease should be irreversible.
No. What I'm saying, I'm asking you is it not so that the whole of this form that is at CB11 is a Regulation 29A3 form, and therefore this applicant, because of the manner in which the application was brought, need not have completed Regulation 29A3 form, which is this form. So you can't choose and pick in the form what you, if you choose to complete it, it must make sense at least.
I agree with that. If we look at it, it must make sense, and I'm trying to make sense of why do we have that.
But you can't impugn some portions of it. And that suits what has been put in, and the others. No, let me finish, please. And the others, you want to reject because they are not a requirement of the Act. Because everything that is in this form is the Regulation 29A3 requirement, not Section 79.
There must, whatever's before the court, it must be something that is consistent with the provisions of Section 79. I think that would be the point of departure. It must be consistent. And if it is not, it's not necessary for the court to take that into cognizance. But if it is relevant, it must take it into cognizance. And as on the issue of whether there's terminal illness or condition, that has been addressed. And if it has been addressed,
you see, I'm sure you don't understand what I'm trying to put to you, Mr. McLean. All I'm saying is that this addendum, the applicant need not have completed. It chose to complete it. It placed it before the National Commissioner for consideration. And we can only presume that it was before the Commissioner when the decision was made.
Indeed so.
So we've got to interrogate what was put before the Commissioner and how the Commissioner understood what the Commissioner drew from the document as a comprehensive document.
Yes.
So you can't, when there are portions that are completed in a manner that we don't understand, say, no, ignore that because that portion is not a requirement of the Act. But you can consider others because they are completed and they are they were before the Commissioner.
But Justice Doubles, if any, and this is what the appellant is being accused of, to say he did not follow the Act. So if something is not consistent with the Act, it is not necessary for the court to take it in consideration. The court must then say that in itself is not consistent with the Act.
Yeah, the whole form was not consistent with the Act.
Not the whole form.
The addendum.
Not the whole form. I've pointed out.
I'm talking about the addendum. It says so at the beginning there that it's a Regulation 29A3 document. It's not a document that's required under the Act. And I'll just say that for the last time. It speaks for itself.
Yes, let me just refer to Regulation 29A3. It says when a head of a correctional center receives an application for a medical parole, he or she must refer the application to a correctional medical practitioner who must make an evaluation of the application in accordance with the provisions of Section 79 of the Act and make a recommendation to this Act. Now, it talks about a medical practitioner. It does not talk about the parole board. And if this is the medical practitioner's report that is now required in terms of Section 79(2). Hence, it deals with the issue of making an evaluation as to whether that application complies with the provisions of Section 79. Okay. Is this one?
No, that's fine, Mr. Mpahlele. I think we've heard what your submission is in that regard.
The next point that I wanted to deal with.
Yeah.
I think it has to do with the medical report, and I think I've already alluded to that point. And just maybe in conclusion, I would rather say that the report that is referred to in 79(2)(c) is the one that deals with the issue of the medical diagnosis and prognosis of a terminal illness or physical incapacity from which and for that I would refer to the code to 79(3)(a). No, not 79, I mean 79(2)(c). Now, 79(2)(c), it talks about what must be dealt with in the report that is required from the medical practitioner. It says that written report must include, among other things, the provisions of a complete medical diagnosis and prognosis of the terminal illness or physical incapacity from which the sentence offender suffers. 2, a statement by the medical practitioner indicating whether the offender is physically or incapacitated as to limit the activity or inmate self-care. And 3, the reason why the placement on a medical parole should be considered. So, a report in this instance that deals with all these requirements of 79(2)(c), Roman figure 1, 2, and 3 is the report of Martha. That's the point that I was making earlier on. And the report by the medical advisory and parole board, therefore, cannot be the one that makes that determination as to whether the sentence offender is terminally ill or not. That report is an additional one wherein it will make a recommendation in terms of whether medical parole should be granted or not. So therefore, it is not binding on the National Commissioner. It has been as it has been submitted by the respondent. The National Commissioner has a discretion on whether to accept that report of the medical parole and advisory board or not, because the discretion to grant or refuse the medical parole lies with the National Commissioner, and it does not lie with the board.
Can I just ask a question though on the discretion? The first question is that the board dealt with both or considered Dr. Mafa and Dr. Mpatswe's reports. Is that correct? The advisory board.
Correct.
And having considered those, then they made a recommendation.
Yes.
And they are medical people, they are medical specialists, correct?
Yes, but whether the specialist...
Okay,
yes,
the question,
yes,
the medical specialists. And now the discretion by the commissioner, not being the medical person, you're saying that he can choose which report he thinks is the correct report for him to approve the parole. Is that correct? He can choose which report he would consider, whether the independent report of the board or the medical practitioner's report. You say he has the right to choose.
No, he doesn't choose. He must consider all of them.
He considers, but he prefers one. Isn't that right? Isn't that what you're saying? He preferred the one of Dr. Mafa and Dr. Mpatswe.
If he agrees
Okay,
with
if
the
he agrees.
contents.
Okay, he agrees with the contents. On what basis does he agree, or what informs that agreement, him not being a medical specialist?
It is not for the first time that administrative organs that are afforded the right to make certain decisions, even though they don't have, for instance, and it's not for the first time that the medical parole has been considered, even though by the National Commissioner, even the National Commissioner does not have the medical experience. One, the doctors that examined Mr. Zuma are the ones that are recommending that he be placed on parole. Those that examined him. And none of those that examined Mr. Zuma are recommending that he be placed on. They're not even saying he's not terminally ill. They're saying the condition is stable. So that's the reason why the National Commissioner said, but if you are medically stable, does not necessarily mean that you do not suffer from a terminal illness. It must have stabilized at that point in time because of medical intervention. And it cannot be said that now that is no longer terminally ill. And it is on that basis that because they are not saying it's not terminal ill, it's just only stable, that he decided that, those that are saying he must be released on parole, particularly when he said Mphatso says he must be released on parole immediately. I've dealt with a number of other parole matters. And in those parole matters where the parole would have refused the parole. And when it has refused the parole, if ever there's a report, which in itself should have been considered by the parole board, which in itself would have changed the mind of the parole board, in most cases we find difficult to justify why didn't we grant parole, because there was a report that is authorized that the person be released on parole. So similarly on this one, if there are two reports of the people that examined the Mr. Zuma that says that he must be released on parole, there must be a reason why the National Commissioner should ignore that. And what has been suggested is that the National Commissioner should have ignored that, even though that the reports are saying, well, after all, is suffering from terminal illness or condition, it should have ignored, even though the parole board is not saying that it's not suffering from a terminal illness. I think such an approach would be wrong.
What would have been the purpose for Parliament to establish the parole board? Why was it established?
The provisions is very clear. It's very clear. It was established in order to provide an additional report, an independent additional report, which needs to be considered by the National Commissioner. And he has done so. And he has done so.
And it was constituted in such a way that it had a number of medical practitioners who would give an aggregated view and make a factual finding of the condition of the applicant. And there is a provision, I forget what it is, in terms of which the majority decision becomes the decision of the board. Why would the legislature go to all that trouble of putting together a body of 10 or 11 medical practitioners who would decide by way of majority what the condition of the applicant is, if their decision would be considered similarly as the applicant's or as the applicant's doctor.
Is to provide the National Commissioner in this instance with the widest possible expertise for which to consider. But the fact that the board in itself is constituted by the experts does not elevate its report to be more important than any other report that is before the National Commission.
It's a statutory
it is an
body.
Additional report.
It's a statutory body.
Indeed, the statute is very clear. It's very clear. It is an additional report. It's in addition to the medical report referred to in subsection 2C.
And it carries the same weight.
In this, but all the
Sorry?
one,
It carries the same weight.
What I'm saying is the one that deals with the issue of the prognosis and the diagnosis is the one in 79 2C. That's the one that deals, and it is provided. C is clear that it deals with all those other things. And it said over and above this report, there must be an additional one from the parole board. So the way it has been projected by the respondent is that it is binding, and that's what even was found by the court acquis, that it is binding, that its recommendations are binding and final, and for that they even make reference to the Kimberley School case, which we have submitted in our case, that it is irrelevant because the provisions are totally different, and the report of the parole, it seems to be elevated, which we're saying it is not correct. It is not a proper reading of the provisions of the Act.
So it carries the same weight as the applicant's.
It must be treated equally, and whichever provides information that convinces the National Commissioner, he can decide to follow.
Yes.
I think in the process of responding to questions, I've dealt with this issue of the fact that Dr. Mafa examined Mr. Zuma, of the fact that he made reference to the fact that he's suffering from a terminal disease or a condition that he was rendered physically incapacitated, and that he should be considered for parole. And I've also dealt with the fact that there's no way in the way the board says that in their recommendation that Mr. Zuma is not terminally ill and that he's not physically incapacitated. There's no way in their report where they state that. So all that the board states is that he was stable and does not qualify for medical parole. So the very same criticism that is leveled against the appellants, that your reasons do not state that is suffering from a terminal illness, can also be leveled against the parole board, that they say, no, he is not terminally ill, he is not incapacitated.
Okay. I think you have dealt with the
yes,
contents
can I just move quickly to the issue of the remedy?
Yes. Now, because of the time, I'll try and be as short as possible. Now, the court accord, in paragraph 95, that is on volume 6, page 1038. At 1035, says the following. Paragraph 95, the consequential relief sought, sending the third respondent back to prison to do his time, and order that the time spent on medical parole should not count towards fulfilling his sentence, will not impact him unfairly, as there is no suggestion that he is
an innocent party. And that's the reason why. They want to send Mr. Zuma back to jail, because there's no suggestion that it's an innocent party. Now,
well, isn't that simply a consequence of setting aside the decision?
That's the reason.
No, I'm saying once you set aside the decision, it is a nullity, and it's always been a nullity, which means that the status quo ante applies. In other words, he has to go back to prison. There's a slightly different issue relating to the second part, whether any time spent on medical parole should count towards his sentence. That's a different issue. But the first part of it seems to me to be pretty much uncontroversial.
Obviously, when the court had to look into that, it has to look into a remedy that is just and equitable. And in determining a just and equitable remedy, it then came to the conclusion that Mr. Zuma is not to be blamed. I don't understand how it arrived at that finding, because surely Mr. Zuma is not the one that has granted himself parole, and therefore he was not party to that particular decision.
Are you dealing with the order of the court of course setting the decision aside, or because as I understand my colleague, he's saying that once the court of course set aside the National Commissioner's decision, then there was nothing else other than the status quo ante, which meant that the offender goes back to prison. But as to the second part of the order, as to whether the parole period should be considered, should there be a further application or whatever, or should be considered on its own as having served, it's a totally different question.
Indeed, maybe let me just deal with the issue that justices are now raising of whether the period that has already been served under while Mr. Zuma was at home should count towards the computation of the 15 months
Okay, can you
prison.
just deal with the first issue first? Because there's two parts to the question. The question that you're being asked is whether or not, if the court reviews and sets aside the decision, the status quo ante prevails. So the consequence that you've read in paragraph 5, that the second appellant goes back to jail, is a consequence of the review and the setting aside. Do you agree with that? That's part one of the question that my brother and sister put to you. And then the second issue that is being said is that the question of whether or not the time out should be considered is a separate issue altogether, and there's other questions there, whether or not it's appropriate for the court or it's the commissioner's decision to make. That's a separate question. So if you don't mind, can you just answer both questions separately?
I can do that. I thought the first one was a foregone conclusion, but I can deal with that. In respect of the first one, surely if a decision is found to be unlawful, in that it infringes the principles of legality and is being set aside, right? The consequence would then be, one, and this is our submissions, that this will then be a case because of it will be, there are no exceptional circumstances. It will be the case that should be reverted back to the National Commissioner, for the National Commissioner to consider the whole question of the medical parole afresh. More so that currently the National Commissioner is a new National Commissioner. It's not the one that took the decision. So it cannot be said that it was a foregone conclusion. That's the first one. The second question, it is the issue relating to whether the time which was served by Mr. Zuma while under medical parole should be counted in terms of computing the period for which he has been sentenced. Our submission is that parole in itself is a punishment. It is a punishment within a whole system of corrections. And because it is a punishment, and there's authority to that effect, the Parker's case that it is a punishment, therefore, if that period is not taken into consideration, that will amount to a double jeopardy. Because Mr. Zuma was not free.
Who should
During the
make
time
that
that was under medical parole, there were conditions that were imposed on him, and those conditions are even very clear if one looks at
Mr. Mpahlele, who should make that decision? Is it the court that should make that decision or the commissioner?
the decision to do what?
Whether or not the computation of the time out should be taken into account.
The court has already made a finding on that. And therefore, our submission is that that in itself, in coming to that conclusion, it is aired, and that this court must then say that that should then count. In the event that they say that, the matter shouldn't go back, and then it shouldn't be considered by the National Commissioner, that the court can substitute its own decision based on the facts of the case for the decision of the court. And on the issue of whether it can substitute, and our submission was that and I think that's the point that Justice Plaskett was trying to converse with me, that we say that the court was not having the full record that was before the National Commission, because the record that was before the National Commission itself was redacted, and because it has been redacted, it was not in the position of which the National Commissioner was for it to have substituted. The best remedy should have been to refer the matter back.
Yeah, but that order was premised on the finding that the weight to be accorded to the decision of the Medical Parole Board bears more weight. If we are not with you on your submission that the other medical report weighed as much, then, and if we think that the Medical Parole Board decision stands, and what it means is that the terminal illness, physical incapacity requirement, jurisdictional fact had not been established, then that would mean there is no pending parole. There would be no pending parole application before the National Commissioner. Am I right? If that's what we are of the view of, as the quota quo was.
Even at this stage, there's no pending parole application.
Sorry?
Even at this stage, there is no pending parole application, because the parole application that was before the National Commissioner has been decided.
Yes.
So it's not pending.
No. But when you say it must go back, what would the Commissioner decide on?
The Commissioner would have to, because the decision, the parole decision would have been set aside. Then what happens is that after all, then the application then must go back to be considered, because that decision has been set aside. Then the application will have to serve before another National Commissioner, who's the
on the same papers.
On the same papers, yes. He has to look at it, taking into consideration what the court would have said in terms of what was wrong with the previous decision that was taken by the former National Commissioner.
Okay. Just one more point. I'm not sure whether you had finished. What do you say about the other jurisdictional facts, the consideration of propensity to reoffend? Did the Commissioner look at that?
He has looked into that one. And
where do we go for that?
And one of the reasons, and I could see...
Where do we go? Where do we go for that reasoning of the Commissioner in respect of that jurisdictional fact, and whether he would be able to have the same, the required medical attention or care?
volume 4.
I know he does say in the affidavit, in his answering affidavit, that he did, but as you know, we would expect to see that in his reasons, where he was saying, this is what I considered. Those CB 11, 12, CB 14, where he sets out his reasons. He doesn't seem to refer to any of those considerations.
It is part of the papers before the court. The answering affidavit on 7/11.
So other than the answering affidavit, there's nowhere else. It's not in his reasons.
Paragraph 13. Going back to paragraph 13. Where we all know that Mr. Zuma was released into the care of his wife, Ms. Bogingebe, and that itself deals with section 79(1)(c. Because that is 79(1)(c) deals with the question of whether you have a.
Look, Mr. Mpahlele, I'm not going to belabor the point. Yes. You know what the respondent's submissions are in that respect. Jurisdictional factors 2 and 3. What I wanted to give you an opportunity to do is to make your own submissions in that respect, because you haven't.
Yeah. Okay. In respect, it is mentioned in the reasons that we're talking about Mr. Zuma, who's about 79 years old, and who's a very low risk of reoffending, because they are saying he is still defiant of the Constitutional Court because he continued to make statements outside the court relating to his attitude.
No, apart from that, they are saying the commissioner did not consider that factor as to whether he is a person who's likely to reoffend.
He did, because for him to take into consideration of his age, that is of an advanced age, he has dealt with that one. And secondly,
so an old person doesn't reoffend.
It's very unlikely that a person of 79 years old would reoffend. A 79 years old is a very of advanced age. That's the first thing. And secondly, he was released. He was released in the care of somebody that would be able to assist. And also, is also having medical assistance available of the South African Military Health Services, being a service that is provided to former president, and the kind of service that is not even available in the prison facilities.
Okay. Those are your submissions.
Those are. May I just find out if ever from my junior, if there's any other thing that I need to do.
We'll take it here. You'll still get the chance to reply or to respond.
I think there's just one more point, which was brought to my attention by my junior. That is in relation to volume 6 on 1014. Here on paragraph 29, the court says, on the same day, 20 days after the third respondent was taken into custody, Dr. Mapa applied for medical parole on behalf of the third respondent. In the application, Dr. Mapa stated that the respondent was suffering from a terminal disease or a condition that is chronic and progressive. He stated further that the third respondent condition has progressively deteriorated since 2018 and is unable to perform the activities of daily living or self-care. He recommended parole as a result of incapacity. So that in itself shows that Dr. Mafa dealt with the requirements of Section 79.
Just one last question from me. As I understand, your submissions differ from the second appellant submissions in that primarily the provisions we're looking at is Section 79(1) as being the one that is applicable and that which the Commissioner considered the application in terms of. Is that right?
I don't seem to
I'm saying the provision that's applicable according to your submissions is Section 79(1), and your case differs from that of the second appellant in that respect.
The respondent are saying the requirements of Section 79(1)(a) are determined by the Medical Parole and Advisory Board. And that once the Medical Advisory and Parole Board has given a positive recommendation in respect of whether a person is terminally ill or having suffered from a terminal disease or illness or incapacitated, then the only thing that the National Commissioner will have to do is to consider Section 79(b) and (c). He's not entitled to look at 79(1)(a) because he's not a medical expert. That's the contention of the respondent. We say no, that is not correct.
Now, my question is, you agree, according to your submissions, that the provision of the statute that was considered by the Commissioner is Section 79(1).
The Commissioner has made it very clear in the reasons that he took the decision in terms of Section 75(7) and 79(1) of the Act.
Okay.
Correct.
In other words, Mr. Mphahlele, Section 75(7) is the enabling provision. Then 79(1) is how we do it.
Correct, Justice Mahlo. That's correct. Unless justices will want me to make any further those will be our submissions from the first respondent. As the court pleases.
No.
And we therefore request that the appeal should be upheld. The judgment of the court shall be set aside and substituted with an order dismissing the three applications with cost, including costs for leave to appeal and cost of 2 counsel. However, on the issue of cost, there is a submission by the respondent that they would want to rely on the by-watch case, and then our contention is that the submissions that were made by the respondent are completely misplaced and based upon the desire to have the second respondent punished and not to ventilate the rule of law. On those bases, we believe that should be ordered to pay the cost of the court cases.
Before you sit down, Mr. Mphahlele, if we are not with you, and you said we should then consider remitting the matter to the Commission, and you made the point that there is a new National Commissioner, Mr. Tubakale. Mr. Tubakale has made pact with Mr. Fraser. He says the decision is correct. That talks to whether the decision is not a foregone conclusion. He says that decision was correct.
Mr. Tubakale said the decision is correct based on his interpretation of the Act. And if the court was to say to Mr. Tubakale, you are incorrect. You are incorrect because if one were interpret the Act should be interpreted as the way it is submitted by the respondent and the way in which we are interpreting it. That gives him an opportunity to consider that and to decide whether to say, the court is correct.
So the fact that he says in these papers that that decision is correct, does not, you submit, does not make his decision, if we remit to him, a foregone conclusion?
No, it doesn't make his decision a foregone conclusion. And more so that if one looks at the submission that are made by the respondent, they're accusing of the former National Commissioner of biasness, of irrationality, of any relationship that he had with the former president previously, which are not the issues that they can raise against the new National Commission. As the court pleases, those will then be our submissions.
We'll take a 10-minute tea adjournment.
Will be coming in any time from now. Basically what the Department of Correctional Services was saying through the legal representative, Senior Counsel Mphahlele, was that the National Commissioner was authorized to do the decision that he made last year to release the former President Jacob Zuma on medical parole, and also arguing that the report or one of the recommendations of the Medical Parole Advisory Board is not a deciding factor. In fact, the National Commissioner actually has to consider all the reports and then make his own discretion on what he will make out of all those reports. And in this regard, the National Commissioner decided to release the former President Jacob Zuma on medical parole. But he did face some really serious questions from the judges, questioning the lack of information within the decision that he took, the National Commissioner took last year when he was releasing the former president on medical report. Desiree, with that is back to the studio. The judges are coming in now.
Just ask questions. Oh yeah, I was saying, can you please, I need two people, I need Zoom and so I think you must stay and try to ask your engineer to yes, so I need
No, wasn't I need to get was decided we want
I may ask the court for an indulgence, just to give me a few minutes to outline the ambit of my approach. And I do so because I'm concerned by two things. One is that we are here now, and two things that have not been mentioned at all. One is the human rights of the person, the inmate, particularly in respect of what I've referred to, or what we refer to in our heads as the so-called residuum principle. And I will address the court in respect of that, because that should be our starting point as to whether any constitutional rights in all this have been infringed, limited, violated, or not. And of course, I'm not blind to the fact that one cannot be selective about the Constitution. Section 33 of the Constitution about administrative rights is also part of the Constitution. So I'm not saying that let's look at the Constitution selectively. And we know that PAJA derives from Section 33. The second concern I have at that broad level is that until Justice Makgoka, very late in the day, question, there was absolutely no reference or mention of Section 75(7) of the Act. Now, let's just park that. I'll come back to those. If I may, while I still have this leeway, just situate my argument. I was making this metaphor with my team. It's a hunting metaphor. And I say, more than us talking about what is in our own armory, which is our heads of argument, I'd like us to talk more about the prey, the kill, the target, which is the judgment of Matojane J. And later I will explain why I'm taking that approach. Of course, we'll be using our heads of argument as a form of attack, so to speak. Now, if we take that approach, then I'm going to raise, just in case I run out of time, I want to raise up front 12, a dozen of the issues that I will deal with. If I run out of time, some of them I might deal with them in reply. But those can be grouped into three categories, and that's where the metaphor of the wild animal comes in. Because it has a head, a body, and a tail. Those are the three parts. The head, by the head I talk about the points in limine that we raised, and I will isolate only one issue there, the issue of mootness. And I do so for a particular reason, because it is important in its own right as a point in limine, but as we know, the animal is still one thing. So there's interplay between these three things. So the issue of mootness, in my respectful submission, also has a bearing on the issue of remedy, which is the third element. So the head is the points in limine. The body is the merits of the rationality stroke lawfulness test. And the tail is, of course, remedy. So those are the three constituent parts of my argument. And very quickly, these are the issues that I'm going to raise. The first will be that there's a contradiction within the judgment that goes to the heart of the issue that is defined in the judgment, ironically. The judgment itself defines the issue, and then it then self-contradicts. The second is that there is a misrepresentation of what the board actually said, and I'll explain that. The third one is that there is this issue about the section 191 A, B, and C. Justice Dambuza raised that issue towards the end. In other words, the three separate requirements. Then the fourth is that the court says that should from President Zuma have been referred back to escort, he would have had the access to all the medical care that he requested. That you'll find in paragraph 72 of the judgment, and I will refute that statement. 5 is this issue about is not an innocent party because somehow he complains about the manner of his imprisonment. And I will call that when I deal with the double jeopardy, but I'll explain that as well. Seventh deals with this interplay, as we put it in our heads, between section 75 and section 77, where the court says that if our interpretation to those two sections would be given effect to, then there would be quote-unquote unfair discrimination between those prisoners who are serving under 24 months and those serving over 24 months. That's what the court says, I think at paragraph 78. And then, of course, there are the three statutory interpretation errors, for lack of a better word, that the court commits. And these are the court broke what, and this is my terminology if the court will forgive me, it broke what one of the rules of interpretation that I call wag the dog. In other words, you cannot use the regulations to interpret the act. That's a trite principle, and there are authorities that deal with that. Then I've already mentioned the residuum principle is not applied at all. But more seriously, the court did not address an argument which we made about the generalibus principle, which is the rule of statutory interpretation. Generalibus, specialibus, non derogant, or generalia specialibus non derogant. I always say lawyers like using Latin, but it simply means that where there is a special provision and a general provision, effect must first be given to the special provision, paraphrased. And then that was, okay, I think that was about number 9. Then we have, number 10. Then we have the issue about the fait accompli issue, and I'll juxtapose that with the mootness point. I'll explain how that does. That will be 11. Then the last point is that the court is in the same position as the National Commissioner, which again, of course, we will refute. So those are the signposts in those three categories. But if the court will allow me to deal very much swiftly with the difference in nuance between the approach that we take and that taken by the first appellant. It was already alluded to in a question by Justice Mabinla Bokwane. For us, our starting point is that this decision was taken in terms of Section 75(7).
Well, that's not what the Commissioner says.
It is
and he's the person who took the decision. He's pinned his colours to the mast of Section 79. And in terms of Minister of Education versus Harris, he's stuck with that, as are you, I would imagine.
Thank you, Justice Plaskett. No. The issue here is that the Commissioner, and unfortunately, Justice, you came before I finished the sentence. And my sentence was going to end like this, that in so saying, in saying that the decision was taken in terms of Section 75(7), we are not by any means shying away from the fact that the Commissioner said he's taking the decision in terms of Section 75(7) read with Section 79. That was the rest of my sentence. And that is indeed so. It's undeniably so. To agree with you, Justice Plaskett, if you go to CB1, if you go to CB1, you'll be surprised to see that actually there's not even a mention of Section 79 at first. This is the first media statement that was released after the parole. And paragraph 2 thereof says...
So, Mr. Mpofu, which volume?
CB1, the core bundle, my lady.
The core bundle, okay.
Yes, Justice.
Page 1.
Page CB1, yes, correct.
Okay, thank you.
Sorry. You'll see that the second paragraph says, Section 75(7)(a) of the Correctional Services affords the National Commissioner a responsibility to place under correctional service supervision or day parole, grand parole, medical parole, and so on, a sentenced offender serving a sentence of incarceration for 24 months or less. National Commissioner is also, in terms of Section 52, empowered to prescribe conditions for parole. No mention of 79. It is indeed so that, as Justice Plaskett has pointed out, if you go to CB 40, here, then it's the hybridity of the sections is mentioned. But even here, the primary section that is mentioned by the Commissioner in his reasons is 75(7). He says, in terms of Section 75(7)(a) of the Correctional Services Act, as amended, read together with Section 79 and Regulation 29, I, Arthur Fraser, National Commissioner, and so on, must make a decision whether or not to approve an application for medical parole of a sentenced offender. Another emphasis on approve an application. But the point I'm making for current purposes is that even here, even where the hybridity is articulated, the primary section is still 75.7. Why is that so?
What do you mean by hybridity? I don't understand.
No, I mean two. One, two. The first one is 75 and the 79. In other words, the sections, what I'm really saying, Justice Plaskett, in simple terms, is that the sections that that this honorable court is going to have to interpret are two, not one. And this is the point I was making, that the entire debate was only based on one of the two sections, namely section 79.
Well, let's just step back from that a moment.
Right.
Section 75 grants the Commissioner jurisdiction to consider parole applications where a person has been sentenced to 24 months or less.
Correct.
Then you go to section 79 to find out how he does so, what he must apply his mind to, and so on. That's the decision-making section. 75 is simply a jurisdictional section.
No, it's the exact opposite. If you look at the Act, section 75 talks about granting parole, right? That's the empowering provision. The parole, as this is articulated here correctly, is granted in terms of section 75.7. That's undeniable. However, having said that, Justice Plaskett, you are correct that and that's what I call hybridity, the relationship, maybe let me use a simpler word, the relationship between the two sections, or what we've called in our analysis the interplay between the two sections, is crucial, but crucial. And it is this. It is that in whether you are under 24 months or you're 2 days or whatever, surely the commissioner can't just wake up and give you medical parole. That I accept. The commissioner has to apply certain criteria and so on. And that's where the relationship is. But one cannot, and I beg the court not to fall into that trap, negate section 75 and only zoom into section 79.1. And let me explain another reason why. Because I've already gave you the first reason, that the actual parole in this case that we're about today was granted in terms of 75.7. There's no doubt about that. It says so. However, the section 79.1b, by the way, is not as definitive as it is cracked out to be. All it says is this: any sentence offender may be considered for placement on medical parole by the National Commissioner, the board, or the minister, as the case may be, if they may be considered. It doesn't even talk about granting that section. The granting section is section 75, because section 75 reads like this. 75.7, sorry. Despite subsection 1, the National Commissioner may place under correctional supervision or day parole or grant parole or medical parole to a sentenced offender serving the sentence of incarceration for 24 months.
I'm not sure where this point goes, because ultimately the decision-making criteria are in 79, and that is what this case is about. Whether Mr. Zuma suffered from a terminal illness or condition, etc. And the commissioner himself says, at paragraph 13 of his reasons, having considered all the relevant information, I'm satisfied that Mr. Zuma meets the criteria in section 79(1) to be placed on medical parole.
Yes.
So this gets me back to the Minister of Education versus Harris point. Here he has said, I took my decision in terms of 79(1), and that's what you're stuck with.
No.
Because we are dealing with whether he applied his mind properly to those criteria in section 79.
I'll move to another point. I can't belabor this point more. The point I simply want to make, and I will make it to the end of the argument, is that if anybody, if I were to come here and say, just look at section 75, don't look at anything else, I would be dead wrong. But similarly, anybody who says, just look at 79, will be dead wrong equally. That's all I want to say.
I don't think anybody says ignore 75(7). I think we are on board.
Then I'm happy.
That 75(7) should be read with 79(1).
Absolutely. Then we're on the same page. Thank you. Then I'm sorry, Justice Cousins. I'm sorry.
Can I just clarify? You accept that they have to be read together?
Absolutely.
The solution in your head is paragraph 10.2.
10.2.
That would need to be adjusted somewhat.
Absolutely.
Because there you suggest that 75(7) is an alternative pathway.
No,
without reference to 79.
Now let me explain the alternative pathway theory. No. By doing that, thank you so much, Justice Person. I'm at pains to eschew what I thought Justice Plaskett was accusing me of doing. I am not at any stage ever saying that we must only look in a blinkered fashion at 75(7). Please, I'm not. And I accept that the two must be read together. Coupled, they must be coupled. That's all I'm saying, is that whether you read the one or the other without the other, you are wrong. That's all. That's the only point I'm making. And I'll go as far, Justice Hossen, as saying that in our response to the agent application, to the very first one, it might well have appeared that we were putting too much emphasis on 75, and maybe we did. But since that, in the supplementary papers, in the heads here, in the notice of appeal, we've made it clear that we accept wholeheartedly what I call the hybridity of the two. We do. So I just want to put that to bed here.
Can I just get
Now,
further clarity?
I'm sorry, Justice.
Sorry, Mr. Mpo, further clarity. If we accept 75(7) is read with 79(1), the provision we look at to see the factors to be considered is 79(1) and not 75.
Yes.
Yes. So that one has no list of factors. The list of factors is in 79(1).
Yes.
Okay.
I accept that wholeheartedly, by the way. And the reason why I accept it, all I'm saying really is a simple point, that the starting point has got to be, as Justice Plaskett said, what the decision maker says. The decision maker says, I've taken the decision in terms of 75(7)A, read with 79.
I must say that your heads sent us the wrong way. Me, if I'm speaking for myself, it did.
Okay.
Let me. But I'll accept. I will definitely accept what you're saying now. But if you look at even paragraph 61, 62, 50, 61 and 62 are more explicit. But what matters is that now you say that the two provisions must be read
just to put the matter to bed. If you go to paragraph 42 of our heads, 41 and 42, it's made abundantly clear. We say the application is is doomed to fail because it is based on false foundation. All three respondents have disingenuously and deliberately approached the matter on the clearly incorrect premise that the impugned decision was based exclusively and solely, and that's the point I'm making, on Section 79 of the Act. However, and in truth, the decision was based on, and then I quote directly from what I've just read out to the court, Section 757 read together with Section 79. And then if you go to the next paragraph, it will say, the fact that the decision was mainly based on Section 757, albeit read with Section 79, for understandable reasons, the ones that have just been articulated by Justice it cannot be wished away, deceptively edited away or ignored. It is an inescapable fact, it has legal implications, and it must be squarely confronted for what it is. And now, let me quickly then run to 79, because as I have accepted the issue, the formulation as summarized by Justice Mabintla Bakwan. Now, we then go, the best place to go to for that is the judgment. Because the judgment, for all its flaws, isolates the issue at paragraph 8. No, I've got it's as follows. The case for the applicants, today's respondents, in other words, their case to establish, is that the third respondent does not satisfy the requirements for medical parole set out in sections 79(1) for the Correctional Services Act and so on, in that, to use the words of the subsection, the third respondent is not, quote, suffering from a terminal disease or condition, or is not, quote, rendered physically incapacitated as a result of injury, disease, or illness, and so on. Now, that is the case that is brought here, that was brought by the applicant. And that's where the intersection between the two sections begins and ends, by the way. It is that what they are saying is that, yes, you may have, because of the length of the sentence, you as National Commissioner have the power to act, to grant. However, as the respondents were saying, in doing so, you failed to establish one of the criteria, which is the issue of the terminal illness. That's the beginning and the end of their case. Now, if
nothing about the other jurisdictional.
No, they don't raise them. They do, in fairness to them, they raise them in the papers. But their case is as articulated by the learned judge at paragraph 8. Oh, okay. Yeah, that's what I'm saying. I'm not denying them the fact that later on they will, in any event, this, that, and so on. But the case is the case. Now, that's the case we were called upon to meet, and that is the case that we have met exceedingly, as I will demonstrate now.
On the affidavits?
Everywhere. On the affidavits, in fact, ironically, even in the judgment itself, the one that we're here about. If you go to paragraph 29 of the judgment, Justice Dambuza, you'll find the answer there. The judge says, on the same day, 20 days after the third respondent was taken into custody, Dr. Mafa applied for medical parole on behalf of the third respondent. In the application, Dr. Mafa stated that the third respondent was suffering from a terminal disease or condition that is chronic and progressive. Full stop. Not only does Dr. Mafa say that, but don't believe me and don't believe Dr. Mafa. You must just believe the Helen Silverman Foundation. As quoted at paragraph 768 of our heads, with a reference to volume 4 at page 610 of the record. This is what the Helen Suzman Foundation says. In the application for medical parole, they should have said doctor, but that's fine. Mr. Mafa states that Mr. Zuma is suffering from a terminal disease or condition that is chronic and progressive. It's not me, it's them. They are saying in the application, Dr. Mafa states that Mr. Zuma is suffering from a terminal disease or condition that is chronic and progressive.
Is that an agreement with the statement, or is just a restatement of a statement?
I'll take the worst of those. Let's say it's a restatement of a statement. So, as a restatement of a statement, how does it end up? In the application, Dr. Mafa states that Mr. Zuma is suffering from a terminal disease or condition that is chronic.
What is the point you're trying to make? Because I don't understand that.
Yes. This is the point I'm trying to make.
If I repeat what somebody has said, I do not necessarily agree with it.
No.
In my judgment, I must say, Ms. Mpofu said this in his submissions. I do not necessarily agree with that.
No. Justice Makoka, if that is going to be the retort, and I know you are testing the submission, then that would be totally out of place. Let me explain why. Remember, one of the issues that has been put repeatedly to my learned friend, Mr. Mpahlele, is that, in fact, this is their argument. You'll find it littered in all their heads. Nowhere, they say, nowhere do any of the medical practitioners state that Mr. Zuma suffers from a terminal illness. Once you say that, then Justice Mahoka, then it doesn't matter whether it's a restatement of a statement or whatever. That statement, therefore, is false. Because you cannot say nowhere does any of the medical practitioners involved in this matter state that Mr. Zuma is suffering from the same illness. And in the same breath, you say Dr. Mafa states that he's suffering from a terminal disease or condition. That is just palpable inconsistency in what you're saying. Okay. You may say, as I think that's what you're alluding to me, Justice Mahoka, that Dr. Mafa, I'm sorry, I'm thinking about another client, too many Mafas and Mafas. That Dr. Mafa, you may say, I take him to task, or he was drunk, or whatever. But what you cannot say is that he nowhere does he say that there's a medical illness. That's all I'm taking issue. Thank you.
Okay. But the answer obviously would be to go to what Dr. Mafa says. If we want to see what is the correct statement, we would have to go to what he says. Whether or not they say what they say it really may not take us that far. What is important is what Dr. Mafa says.
Very true, my
So,
lady.
yeah.
Therefore, let's go to CB11. Thank you. Let's go to CB11. It's, yes, CB11. It's clear, crystal clear. You know, that's what's nice about these multiple choice questions or yes or no questions. The question there under D says, is the offender, that would be Mr. Zuma, suffering from a terminal disease or condition which is chronic? The answer is yes.
Yes, ma'am.
So,
Mr. Mpofu, you have to read that completely, because that question has 3 subsections.
I'm going there.
So you have to read them completely to complete the answer. So the terminal illness is not only in respect of chronic and progressive, it's also in respect of the third part, which is whether it's permanent and reach irreversible state.
Believe me, I'm going there.
Okay.
I'm going there.
Even what you have read, sorry to do this, even what you have read, Mr. Mpofu, before you even go past, I don't understand what it means, really.
Okay.
Because the question says, is he suffering from a terminal illness or a condition which is chronic? The response is yes. What does that mean?
No.
Yes to what?
No. I also read it like that at first. No, that's wrong. That way of reading it is not, to understand the word condition is merely an alternative to the word disease. And for that, you will find in Section 79 itself, my colleague. If you go to Section 79, it makes it very clear. It says, that one of my juniors was saying, that section has got too many O's, and that's where the confusion arises. Look at Section 79. It says, any sentence offender may be considered for placement on medical parole by those role players if such offender is suffering from a terminal disease or condition. Right? So the word condition is merely a synonym for the word disease. It could be condition, disease, illness, it would mean the same thing. So it shouldn't confuse anybody.
Well, how I read it is that, is he suffering from a terminal disease, which is self-explanatory, or a chronic condition?
No. Go to the Act, my lady. Let's read it together. Such offender is suffering from, on your reading, it will then go like this. Such offender is suffering from a terminal disease. Let's put that aside. Or condition. What is that? There's nothing called a condition.
Well, it says a condition which is chronic.
No, it doesn't. It says or condition, or. It doesn't say that. It says such offender is suffering from a terminal disease or condition. One thing. Or, sorry, I've lost my place. If such offender is rendered physically incapacitated.
No, so, I'm sure we're reading different documents.
Section 79(1).
I was on the.
Oh, you're reading like
on the form.
No. Go to the Act, my lady.
Yeah. Okay. Explain what you want to explain.
The Act, Section 79(1) says, my lady, this is all in aid of demonstrating the submission I'm making that the word condition is merely being used as a synonym for disease.
So in other words, that first question there was supposedly a parody of 79A.
Absolutely, it purports to be, but synthetically it causes the confusion that Justice Tambuza is alluding to, and that's why I'm sympathetic, because I also had the same, my first reading was, I thought this condition must be something else. No. Section 79, and that's because if you sit with this form, actually you will never resolve that problem until you must go to the Act. If you go to the Act, it is crystal clear that you can't say you're suffering from a condition, therefore you must go on parole. Surely, that can't be any...
But you may suffer from a terminal illness, or you may suffer from a condition that is chronic.
Yes, but
that's not what the Act says.
You may, but that's not what the Act says. Maybe when the Act is amended, that might be so. But for now, all you are required to suffer from is a terminal disease or condition. As I said, they could have said, or illness.
Well, I suppose the argument is that one would have expected then that if the application is premised on a terminal illness, that's what Dr. Mafa would clarify in completing the document. No, because he knows that this is the basis on which I'm recommending this parole.
But he did, my lady. That's what I'm saying. Read the question, that question before the question mark alongside the Act. It says, is the offender, Mr. Zuma, suffering from a terminal disease or condition? And I'm saying it says, which is chronic, that terminal disease or condition. Is it chronic? Yes.
But you don't know why.
Why?
So if let's just get back to first principles with expert witnesses. An expert gives an opinion. That opinion is worthless on its own without what comes before, the reasoning, the application of their expertise.
Right.
Okay. And here, all we have are Dr. Mafa's, a series of conclusions by Dr. Mafa without anything else that we can see.
Great. Thank
so
you.
we cannot, how much weight can one attach to, we attach to something like this?
Thank you very much, Justice Plaster. At least I think we are moving. As long as we accept that, and I don't accept it, I'm just for the sake of argument, as long as we accept that Dr. Mafa makes the blank statement or whatever the formulation he made, that the patient is suffering from a terminal disease or condition, then we're good for base one. Let me come to your question.
Before you go to the question, perhaps just to and this is to assist you in the making of that argument, because it seems to me that the critical question is the one that my brother raises. Right. So perhaps just to assist you in moving forward, if you look at the note at the bottom of page CB11.
The MB.
Yes.
Yes.
Well, that seems to suggest that you may be correct, because it says a terminal disease or condition is a condition or illness, and then it defines it.
Absolutely.
Perhaps that would have been the shorter argument, but so address my brother's question.
It's a hallelujah moment for me. Thank you very much. That's what it is. That condition there makes it very clear that it's simply a synonym, and this confusion really should not exist if you look at section 79.1. Let's move on to Justice Plaskett's second leg. Now that we all know that Dr. Mafe, as I say in quotes, it makes a blank statement or whatever, expert, unmotivated. But at least we're past that hurdle. Now, that means then, already, as we're here, we are in a different world than Justice Matojani. Because we now all accept that Dr. Mafa, for all his other sins, he has made a finding that the patient has got a terminal illness or condition. Full stop. Let's close that door.
Is it a finding? Is it not an opinion expressed?
It is. I'm not married to, let's call it an opinion. But that he has made that opinion. Okay. And so did Dr. Mphatho, and I'll come to Dr. Mphatho just now. Dr. Mphatho, the only difference between Dr. Mphatho and Dr. Mafa is that Dr. Mpato makes the same statement implicitly, and I'll explain. But Dr. Mafa makes it expressly. So, let me just quickly address this issue about the motivation. The reason why there is the addenda, which Justice Dambuza referred to, and the reason why this thing is called a report is exactly for the purposes that Justice Plaskett is talking about, like any medical report or opinion or whatever you call it. It must be accompanied by, let's call it clinical information or
a comprehensive report of sorts.
Correct, a motivation. Yeah. Now, this is where, if the court will just allow me to please pause on this to address a very crucial issue which arose from this issue about the reduction or non-reduction of information. It is completely wrong to say that the absence of that information which is redacted to protect the confidentiality, the human rights of a patient must now be visited against us to set aside a decision. That's just wrong. Why is that so? Because the absence of that information surely must prejudice the owners-bearing parties who have come to court to say a particular decision is unlawful. They, not us, must then say, given the record, the decision is unlawful. They, not us, made an election with their eyes open not to enforce the rights provided in our law to compel discovery. They, not us, said we are not, it's somewhere in one of the minutes, they say no, we're not going to, it's a letter I think, we're not going to be drawn into this debate about the confidentiality. We know what you're doing with, you wanted to draw us to some parallel litigation. We'll take our chances. We're going to review this on the information that is redacted. They, how can then that be the fault of the person who's asserting his human rights to say, I'm asserting my confidentiality? Or even worse, the person who had no choice, because we wrote a letter to them, to National Commissioner, by the way, and we said, if you dare release our confidential information, we are going to take you to court, let alone the DA and HSF and all these good people. And so both appellants quite literally had no choice in the matter, but they must be punished. Why? Secondly, our law is very clear on this. The maxim omnia praesemuntur rite esse acta has got this effect. And you will find that in, I see one of my learned friends has got the same thing. The third edition of Cookstein Penhold. It says, talking about the standard and onus of proof in these kinds of proceedings. The onus or burden of proving the facts that constitute an illegality ordinarily rests on the applicant, in this case the respondents, the person who alleges the existence of the illegality. That should make sense to any student of administrative law. If, continues the author, the applicant is able to make out at least a prima facie case of illegality, the respondent authority, that is Mr. Mpatlele's client, will then bear the onus of refuting it also known as the burden of rebuttal. Thus, if an applicant wishes to challenge a decision to refuse her a license, she must bring evidence to show that the licensing official concerned acted illegally, that he ignored statutory provisions, for instance, or that he acted in bad faith. The record of the proceedings, if one exists, will be an important part of the evidence. So this is the issue of the record. And then if the applicant fails to make out an adequate challenge, the decision or action will be judged lawful.
Absolutely.
In accordance, sorry, if I could just finish the sentence, madam. In accordance with the maxim omnia praesimentur rite esse acta. And then it says the maxim presumes, we all know what it means, that it presumes that in the absence of a valid challenge, the decision stands. Now,
but I suppose they elected to challenge the decision based on the reasons supplied by the Commissioner and what remains of the unredacted version. Whether they make a case on that or not is for us to decide.
Fair enough. I agree mostly with what you're saying, Justice Tambuji. Yes, okay. Just to save time, I'll just refer you to page 252, which is volume 2. That's the case management meeting. Where all this penned out. That was before Honorable Justice Lidwaba. Paragraph 5 at 253 says, the Commissioner stated that he, is what I've just said, was unable to disclose the remainder of the record because A, Mr. Zuma refused to consent to the disclosure of the remainder of the record in any form, even under a confidentiality regime, and B, parts of the record were in possession of the South African Military Health Services, who refused to transfer possession. Because after all, we're dealing here with a former head of state. So his medical records, by definition, are classified.
Well,
but secondly,
have to go there, do we? We know we're dealing with what we're dealing with, a redacted record.
But what we're dealing with is Mr. Zuma.
We understand how it came about. We read the papers.
I don't understand.
I mean, the reason why we've got a redacted record is neither here nor there. We know what it is. We've read the papers. We understand it. I'm not sure where your argument is taking you.
Anyway, all right. Thank you, Justice Plaskett. So, the implications, my lady, on your question, and that's the part that's why I said I agree mostly with what you're saying. All I'm saying is that once they, with their eyes opened, made an election not to enforce their rights, their procedural rights, to demand a fuller record, then there are the following two implications. A, I agree with your ladyship that their reasons are partly based on the reasons. I mean, their challenge is partly based on the reasons. But that does not take them very far. If that was so, then all applicants for reviews would simply say, just give me the reasons, forget about the record. And once I've got the reasons, I'm good. Let's move. No. The reason why you need both the reasons and the record is exactly because the two are married together. When the National Commissioner says at CB 41, at paragraph 8, for example, let's just take any random paragraph. When he says at 8.1, the following documents were presented for me for consideration. 3 medical reports by South African Military Health Services dated 8 July, 28 July, and 5 August 2021. Those are the reasons. But where do you go to find those report to the record. So the two things are symbiotically related and married for life, because all this what is outlined in the reasons must find expression in the record. The record could be thousands and thousands of pages. Reasons are typically 3-4 pages or whatever. But because the reasons are merely but a synopsis of the record. So one cannot say, but you have the reasons, therefore you don't need the record. No. And and that's why, by the way, they were fighting for the record, rightfully so. I would have done the same thing in their place. But what they then did was to elect to take their chances, quite literally, by pursuing. They could have done the following 3 things. They could have said, we're going to go to court and enforce this record.
Mr. Mbofu, can I ask you?
Yes, Justice.
Is that still a live issue between the parties?
No. It's not a live issue at the moment, except that what it does, Justice Mahoka, is that, in fact, it's a question, the real question is the one I'm raising about Omnia. Who should be prejudiced by the absence of the full record as between the appellants and the respondents? It's only relevant to that issue. And I'm forcefully and emphatically submitting, with the greatest respect, that the absence of the record must prejudice the party that elected with its eyes open, being an onus-bearing party, not to exercise its rights to the record. Now, where is that going? It goes to 2 things. One, and I'm sorry to jump around, but I must just put this point because it's burning in my repertoire. It goes both to the merits as well as the remedy. How can it be, justices, that it is said that, I think it's the last paragraph of the judgment, where Justice Matojana says, that the court, his court, or this court, or any court, has the benefit of the record. I'm sorry, I'm reading at paragraph 99. That's page 1037, volume 6, sorry. He says, the court has the benefit of the record with all information and recommendations that would have been before the commissioner. What? So this court makes an order of substitution on the basis, completely erroneous, that it has before it the record with all information and recommendations that would have been before the commissioner. That's just wrong. It's not there. It doesn't exist. And I think it's common cause even between me and my learned friends. So that's the first implication of this, is that it fails dismally the Trancon test. The Trancon test, as we all know, has as its first leg the fact that the court, for it to even begin to think about substitution, it must be in the same position that the decision maker would have been. And it should actually be what Justice Matojane incorrectly said is the case here, which is not the case.
You see, as I understand Justice Matojane,
yes, my lady,
that concluding paragraph comes from his whole discussion, and if you read the judgment in full,
yes,
the aspect of the weight to be attached to the medical parole board recommendation was quite substantial. or substantial, together with other factors.
Maybe.
As I read that conclusion, it is that from what appears on record, this would have been, I know what this court, being the High Court, has a fair idea of how the decision-making process went.
No.
That's what I think he says. Yes, that's what I read into.
Yes,
so give me my own chance to put it to you before you respond. That from what I see, this is how the decision-making process went, and it was irregular or faulty. Hence, there is no point in sending it back, because on the salient points, this is what will be presented before another decision-making process.
Absolutely. You're quite correct, my lady. That's what he's saying. But the question is on what you just said, the word this. So what is this? This, he says, is the record with all the information and recommendations that would have been before the commissioner. That is completely wrong. Because this, what he has in front of him, is this minus this.
In your own submission, what would be missing? What would be missing?
Okay. What would be missing is the part that Justice Plaskett calls the cocky pen. It's everything that is redacted from the record is clearly missing, at the risk of stating the obvious. But it's more than that. Common sense, in fact more than common sense, just practicality should inform us that those parts that are redacted are the most sensitive, confidential, clearly specific references to the terminal illness that Dr. Mafa says exists. It follows. So, but one doesn't even have to go there. All I'm asking a rhetorical question. How can anybody, one, say that the material before the court is the same material that was before the National Commissioner? No one can say that.
The National Commissioner had sight of everything.
Yes, correct. That's the issue. That's exactly the issue, Justice Mahok. Let's imagine another world where the National Commissioner also had access to the redacted version, and Justice Matojane also had access to the redacted version, and my learned friends had access to and this court. Then I wouldn't make this point. It is exactly because the National Commissioner, unlike Justice Matojane, unlike my learned friends, unlike the DA, unlike the Helen Suzman Foundation, unlike anybody else, had access to the full Monty, had access to the unredacted information. So in which world can we say that without knowing that information that's redacted there could be saying, and I'm exaggerating for effect, could be saying the patient is going to die tomorrow. As I say, I'm just exaggerating for effect.
Or it could say, well, there's nothing wrong with him effectively.
It could. But then whose baby is that? That's the point. It's the owner's bearing party. The owner's bearing party, that's where the maxim comes, Justice Mahogi. You're quite right. Let's assume, let's be fair and say that the information there could say he's going to die tomorrow, or the information there could say, it's fine.
So the real issue. I'm sorry.
But the court is then hamstrung in its review powers.
Yes, it is. Because the party that is asking it to review has not brought the information for that court to review. That's what I've just read out about.
But the commissioner is very categorical about what he took into account. Yes. Of all the things that were placed before him, he says, this is what I took into account. Yes. And that's telling. That's the respondents say, this is what he says he took into account, and it's borne out by what he himself he says he took into account.
Thank you, Justice. But what is this? This.
Well, he sets it out in his reasons.
No, but
that he supplies.
No, I'm sorry, Justice. One cannot do that. If it says at 8.1, I took into account the report of Dr. Mafe, the report of Dr. Dabula, the report of Dr. Dujwa. Those are the reports he's referring to.
Well, as a public authority making a decision, he has the responsibility of making a decision that's informative to all the interested parties.
Yes, but Justice Dabula, how do you know?
So those parties that are interested in the decision will go to his reasons and work out what he took into account.
Yes.
That's what is being put in the spotlight in these proceedings and before the High Court.
100%. But I agree with you wholeheartedly, Justice Tambuza.
Yeah.
But the point of the matter is that, first of all, the National Commissioner is not a sangoma. He wouldn't have said, one day there'll be a redacted version, or there'll be some fight about confidentiality. When he was taking the decision, we must at least accept, he was taking it based on the information before him, convinced in his mind that, and he said that in the interview that was transcribed, he said, I've taken this decision, it will withstand, the last question that was asked by Mr. Vuyomvoko to him, will it withstand legal scrutiny? He said, yes, it will withstand legal scrutiny. He doesn't
have to be a sangoma. All he needs to do is to communicate to the interested party how he took the decision in an acceptable way. And all interested parties and the court is entitled to take him on his word that this is what he considered, and then determine whether the factors that he took into account would stand scrutiny in terms of how he is obliged to perform that decision-making process.
Let me make an extreme example. Let's assume then that he says, these are my reasons, this is the record, it's 100 pages, but all of it is in cocky pen. I'm just using it to explain the intellectual issue, the concept that I'm trying to say. So I'm saying, assume he did that. And he says to the court, I can tell you, court, that in these 100 pages, which are now in cocky pen, there is everything that I took into consideration and I came to a decision. Which court in this country can say, oh, we've got our reasons, and now we've got this 100-page thing with black pencil, and therefore we find that it was illegal? You can't. You have to either know, because remember, reviews are not appeals. Reviews are about the process by which the decision maker arrived at his or her decision. That is what you are reviewing as a court. You are saying, if he says, for example, it might say, I took 2 minutes to read these 1,000 pages. The court might say,
And that process can only be determined from his reasons.
Information. Correct. That's the point.
And the information is in as far as there is one.
Yes. If the information is not there, the party that bears the onus must lose.
Okay, I think we do understand your submission in that regard.
Thank you.
We can move to the next one.
Then perhaps just to clarify one other aspect, Mr. Mpofu, just I don't want to take us back to that point, but you commenced your submissions in that regard with reference to the fact that the judgment of Justice Matajane couldn't possibly justify a substitution, because I think, as you articulated it, patently did not have all of the information before him. But if you read paragraph 99, it starts at the bottom of page 1036, volume 6. You will see there what it's paragraph 99 of the judgment.
That would be page...
It's page 1036 of volume 6. Do you have it?
I'm there, Justice Person.
You will see that this is really the basis upon which the substitution occurs. And it's really not on the basis of an assessment of all of the medical records that are before the judge. Because he says, remitting the decision to the Commissioner will not serve any purpose as the Commissioner will have no discretion to exercise. And he bases that on the determination of the fact that the decision of the parole board is binding. That's a finding. It's on that basis that he substitutes. It's not on the basis of having then all of the records before.
Well, then why did he say so? It must be both at least. Because he says, with all the information and recommendations that would have been, if your Lordship was saying to me, it's both, then I would, but cancer is not on what he says it is.
Well, he references all information, but really the fundamental recommendation, and this is the basis on which that substitution occurs, is that the Commissioner has no discretion, and therefore I'm going to exercise it.
Justice President, believe me, I will address that issue. But I cannot do so without this qualification. It cannot lie in the mouth of this court to say that, accepting what you're saying, Justice Hussain, that it did not also say that it had the benefit of the record with all the information.
No, I think one must accept that.
Yes.
But what one's dealing with on appeal is the order, not the reasons.
Well, that's always, what can you say to that?
Yes.
But because then it means we should not be here, because we should not look at the reasoning of the court. I'm simply saying, Justice Foster, my starting point was to concede the point you are making. But I beg you to concede my point as well, which is that he invokes both in paragraph 99.
Well, there's no doubt that the passage contains that statement.
Oh, correct. Now.
So, Mr. Mpofu, maybe you're going to deal with this issue when you deal with whether or not the recommendation is a jurisdictional fact.
Right.
But I think in your analysis, you missed that the advisory board had actually sight of the unredacted report as well. They had sight of the unredacted parts of the record too, and they came to a conclusion that they did.
Yes. Okay. Can I start with Justice Hossan? I'll come to that.
Yes.
Justice Hossan, remember paragraph 99 is articulated in aid of one thing and one thing only, to justify the fact that the Trancon test has been met. That's why in paragraph 98 there is that quotation of Hampepe J in Trancon. And Trancon, it's tried by now, asks for 4 main requirements, 2 of which are articulated as the gatekeeping requirements, let's call it that, for lack of a better word. One is the fact that the court must be in the same position as the decision maker would have been at the time. In other words, have the wherewithal. And my mere submission in that respect, that test has been failed. 1, because of the reductions. The second Trancon test is then the fact that it would be a fait accompli. And that goes then to the issue you are raising, which is, would the decision maker have any discretion left to take? Now, a decision may be a fait accompli for many reasons, that I concede, and one of them is the one you're articulating. It might be because this particular decision maker is so recalcitrant and dogged in their belief. It might be, as you correctly point out, Justice Hossain, that whatever element of discretion, because of the facts of a particular case, has been removed. But what we must not do is to conflate the two tests, because the test for what is before the decision maker, which is the first requirement, is one thing. But the test for the fair assembly is another. And my learned friend, Mr. Mpahlele, made it abundantly clear that even the test for fair assembly cannot be passed on these facts, because we have a new national commissioner who is not a friend of Zuma or whatever is alleged by these applicants. And therefore, on both the gatekeeping trend contests, they fail. So, can we then go back to what I deviated a little bit, but it's not a waste of time, because then when I do remedy, I won't cover the same ground. But I want us to go back to the core issue, which is the merits of this application. Justice Tambuza, sorry, I deviated. I was actually answering your question and then I deviated because, as I was saying, that point was burning the issue of substitution. Coming back to the terminal illness issue. And I will address both your question and the other question that I had not fully addressed from Justice Plaskett about the reasons, or rather the motivation for the expert opinion. The situation here is quite simple. One need not go into this weighing exercise about whether the recommendation, that's why Matojana J uses the word recommendations in plural in paragraph 99. Because what he's saying is that he has taken into account I'm sorry. If you go to regulation 29A4, and you'll find that, I think it might be in the core bundle, I'm sorry.
You said 29A4.
29A4, my lord. Yes. Thank you. It contains what is one of the biggest things that is missed in this case, and I call it the double recommendation provision. It says the following: the recommendation, remember there's the other report that makes the recommendation to the board itself. Now it says the recommendation must be submitted to the Medical Parole Advisory Board. Who? This is just a grammatical error. They probably meant which, or if they say who, they're talking about the people, but anyway, it doesn't matter. Who must make a recommendation, right, to the National Commissioner. Now let's pause there. So you have a regime that calls for two recommendations that feed into each other. The argument of the respondents is that the Medical Parole Advisory Board is capable, entitled, and within its powers to overrule, ignore, or second guess, these are their words, the recommendation of, say, Dr. Mpatwe or Dr. Mafu. But the board, or rather the National Commissioner, is disentitled, not allowed, to second guess, overrule, whatever they say, the recommendation of the board. How can that be? Because the real reason why this thing is called an advisory board, is because it's like, I mean, this is tight. Ministers and all sorts of people have advisors, and I'm sure they take some of their advice or don't take it. So do many other structures.
Yeah, but that's not the same thing.
No, if you will allow me to finish, my lady, please. There are many other structures that have a similar relationship. One of them is the JSC, for example. It interviews people, makes a recommendation or advises the president to do something. A board of directors, or rather not a board of directors, if you take it to its most basic level, a interviewing panel at Pick and Pay sits, interviews 10 people, and then it has 3, the case is the Kimberley case is almost akin to that. It has, in the Kimberley case, they had 2, I think 3 persons. They had shortlisted I think it was a white person as number 1 and a black person as number 2, a black woman as number 2, and somebody else. The facts might not be as might have been a man or a woman, it doesn't matter. But the point is that the recommendation that they made was found to be rational, which was to employ the black woman or man, just in case someone finds that I've got the gender wrong. That's not the point. Why? Because that was a recommending body, like the JSC, like the Medical Parole Advisory Board. But it can never be that the board of Pick and Pay, the school board of Kimberley High School, or the president is bound by that advice, recommendation, whatever you call it. Why? Because the legislature is not absent-minded, let me put it that way. If the legislature wanted the board to make a decision, a definitive decision, it would have said so. It wouldn't have called it a recommendation. The minute you call it a recommendation, we've had a whole battle in this country, for example, about whether the remedial action of the public protector is a recommendation or it's binding. For many, many years, it was believed that it is a recommendation until the case of EFF Nkandla, so-called EFF Nkandla. And that was because it's an important thing, whether the recommendation is a recommendation or whether it has a binding effect. It cannot be, with the greatest respect, that the board is entitled to ignore the recommendations of Dr. Mpatlo and or overrule them and Dr. Mafa, but its own recommendations assume some royal power.
Just remind me, Dr. Mpatlo's medical report, was he not part of the board?
No, it was Dr. Mpatlo was.
Yeah, that's what I'm saying.
Dr.
That's
Mpatlo,
who I'm
yes,
saying.
yes.
Dr. Mpatlo gave a minority or report or.
No, this is how it worked, Justice Tambuzi. The board, I suppose, for practical purposes, you can't have all those 10 people going to examine Mr. Zuma. So what the board then, it chooses one of their number to do the examination. And this is the point that, again, my learned friend Mr. Mpatlo was at pains to make, that the 2 doctors who recommend, one says there's a terminal illness expressly, the other one says there's a terminal illness implicitly. I'm prepared to concede that. But those 2 doctors have actually examined the patient. Unlike all those other good people. So it's not just a democracy that because they are 8, then...
Well, but if we're going to consider the regulation at all, it says that the board decision will be taken by majority.
Fair enough, my lady. I'm not quibbling with that. It's the same as what I'm saying. If Pick and Pay recommended a person, the board will take a decision by majority. That goes without saying. But that's not the point I'm making.
And I think the binding or not binding argument is not a straight-jacketed argument. You've got an advisory body that has been constituted by legislation to make a recommendation or a factual finding based on their expertise, which the commissioner obviously doesn't have. In other words, the legislature says, we've put in place somebody to make this decision, but we know he doesn't possess this expertise. We're setting up a body that will then assist him on this aspect, and then his recommendation will go to him in order to enable him to take into account together with other factors that are relevant.
Yes, that is indeed so, my lady.
So that recommendation is based on the expertise of these people that have been set up. It's not just, I don't want to say the JSC, but you can't compare it to the JSC really.
Well, it would even be more emphatic because there you have judges, you have people with the real
and politicians.
But yes.
But Mr. Mpofu, the JSC thing may not necessarily work in your favor in the sense that in some instances the Constitution says the President must appoint on advice of the JSC.
Yes.
So I think for me it really depends on what each statute or framework says as to what the decision maker must do with that recommendation.
Yes.
So I think so we can't put really put analogies as to this is what you do with the recommendation because it really depends. Sorry, can I just finish the point that I was going to just come on the point that my sister was making, that for me it's not whether or not it is binding, the recommendation is binding, it's whether or not it's a jurisdictional fact that is supposed to be satisfied amongst the other two that are there in order for the parole to be granted. And so in doing so, the legislature has said, well, I'm going to have an advisory body.
Mr. Mpofu, I'm going to ask you to be patient when
I'm just remember
when Justice Pakwana is talking to you, you can't just say that. He's going to have your full attention.
I'm trying to find an authority, but believe me, I'm listening.
Yeah, but you will ask to be excused.
I apologize, ma'am.
All right.
Yes.
What I was saying is that the legislature has then said, in order for that jurisdictional fact to be fulfilled, I'm going to establish the advisory board that is consistent of medical experts who will then advise as to whether or not there's a medical condition or terminal illness or physical incapacitation, right? And then regulation 29A7 says if that recommendation is positive, meaning if the board says yes, there is a medical condition, then there's a next step. Then the commissioner must then go and consider the other jurisdictional facts. So the role that's played by the advisory board is quite an important and central to the decision-making powers. So it's not just a recommendation that can be ignored. That's all I wanted to say.
If I gave any impression to this court or anybody that I'm saying this is just a recommendation that can be ignored, then I apologize. That's not what I'm saying. I am saying a recommendation, the words used by the statute must be given meaning to. If the legislature of this country has decided to use recommendation, then we must at least start from there. We can put all the other qualifications and so on, but it is a recommendation. That's all I'm saying. and a recommendation from an advisory board. So I want to make examples because I'm not saying that the things are the same. When I say the example of Pick and Pay and whatever, I'm simply going for the principle that it is possible to have an advisory panel of some sort and then the decision maker, and those two things are two different juridical beings. Now, if they are the same, well, then I'm wrong. But in my respectful submission, a recommendation can never be elevated to a binding decision. Now, and the facts of the Kimberley case, which my learned friends rely on, not only the facts, Mr. Mpahlele made this point, even the statute itself is different, is differently constructed. I've just read out a section that has a double recommendation provision from the regulations, but you can read that together with the empowering provision in the Act itself that establishes the board, yes, the advisory board. But I'm not going to take this point any further than this. It says, this is the Kimberley case, which is cited in our heads. And fortunately, it deals with both the issue point I was making and your second point about jurisdictional fact. So I'll superimpose both points. At paragraph 8, it says, in this regard, the HOD referred to the definition of recommendation in the Concise Oxford Dictionary, namely, to put forward with approval as being suitable for a purpose or role. The proposition by the SGB that it recommended someone whom it regarded as not suitable, so the HOD contended and therefore amounts to a contradiction in terms. Okay, that was on the facts of that case. But it shows you what is a recommendation. But let's just jump to cover your second point, which is the jurisdictional facts. At paragraph 11 says, under the common law, necessary preconditions that must exist before an administrative power can be exercised are referred to as jurisdictional facts. In the absence of such preconditions or jurisdictional facts, so it is said, the administrative authority effectively has no power to act. Nobody can argue with that. And then it says, in administrative law parlance, I'm now at paragraph 12, sorry. The head of department's power to appoint under section 653 is therefore dependent on the jurisdictional fact of a recommendation by the governing body. Let me pause there. So there is what one might call procedural jurisdictional facts and substantive jurisdictional facts. The procedural jurisdictional fact is the fact that a recommendation, whatever it is, has been made. To illustrate that, if, let's postulate, let's say Dr. Mafa gives this report, Dr. Mpato gives his report, and then the National Commissioner says, I'm happy with this. If two doctors say this, then I'm releasing. Then he would have missed an important jurisdictional fact, because a recommendation, without putting color to it, whether it's positive or negative, a recommendation must be made. That is what is called a procedural jurisdictional fact. But the substantive jurisdictional fact is whether the patient is terminally ill, right? Now, that determination must be made by the invocation of the following, what is said in the paragraph there. As was pointed out by the Constitutional Court in Sarfu, SA Defense Aid Fund, the very well-known case, remains the leading authority on jurisdictional facts in our law. In that judgment, Corbett J. identified two categories of jurisdictional facts that can be encountered in empowering legislation. The first category, described as objective jurisdictional facts, includes the type of fact or state of affairs that must exist in an objective sense before the power can validly be exercised. Let me pause there. That is a reference to the jurisdictional fact, namely the terminal illness, which must exist objectively before the power can be exercised. That's what, because this is all about the law of ultravirus, what in old and administrative law, Baxter would have called it ultravirus. Now, I've established, at least the first thing I did this morning here was to establish that the objective existence of that jurisdictional fact was articulated by Dr. Mafa, it's even articulated by the HSF, and it's even articulated in the judgment. So let's go on. Then it says, here, the objective existence of the fact or state of affairs is justiciable in a court of law. In other words, it is the function of the court to determine, as this court has been at pains to do, both with my learned friend and myself, the very first issue, because if that objective fact doesn't exist, then we're wasting your time. But once the court determines the objective existence of that fact, then the following happen. If the court finds that objective, the fact or state of affairs did not exist, it will declare invalid the purported exercise of the power. Very simple. Only if the court, this court, or the Court of Justice Tojani with respect, finds that objectively the fact, in other words, the terminal illness did not exist, it will declare invalid. So what am I saying? I'm saying that the recommendation of the medical parole advisory board, which in CB, in the reasons, has been stated as one of the factors. Justice Dambuza put that question to my learned friend. But did they consider the recommendation of the board? Yes, it's in 8.3. And then Justice Dambuza went further, correctly so, to say, but it's no use simply, sorry, I'm looking for the core bundle. It's no use simply to okay. Justice Dambuza correctly pointed out, let's go to CB 41, sorry.
Just before you do that, Mr. Mpofu, it's 1:05 now. Oh. I just want to have a sense of whether you think you would be able to finish before, say, 10 minutes or so, and deal with the relief, or you would rather deal with the relief point, remedial.
The remedial.
Yeah.
Yes. So on the merits, you'd like me to try and finish in 10
Try and,
minutes?
yeah, if you can.
I'll attempt to do so.
If you can finish with
yes, so that we're left with the remedy.
So that we're left with the remedy. If you finish within 5 minutes, then it means we can come back a bit earlier, and then you can finish your remedy.
Thank you. No, then let me round it off like this. And this submission, again, I will anchor. Let me take one step back, and I'll come back to this in reply. The reason why I was saying I was disturbed standing up here without any reference to the constitutional rights is because the starting point should be what is stated in paragraph 35 of the Pasha case. It's a decision of the Constitutional Court Unfortunately, I had it on iPad, but I'll paraphrase. That decision says that parole is a form of punishment. And I know that, that at face value, that sounds like a point about remedy, but I'll explain. It is also a point about. Yeah. It says, Dr. AJ in the Constitutional Court, paragraph 35, said, it could be argued that parole is a privilege, not a right, and is merely a mitigation of the prescribed punishment of imprisonment, not a prescribed punishment in itself. It is simply a way of serving out one sentence in an environment other than a prison. On this reasoning, the rules prescribing parole eligibility do not amount to a prescribed punishment. However, as counsel for the respondents correctly considered, we are not so lucky. Parole is still a manner of serving out one's sentence. It is therefore still a punishment, although a lesser one than imprisonment. It still amounts to a deprivation of liberty for a short period, albeit outside prison. Parolees remain subject to the supervision and authority of the department for the remainder of their sentence. That it mitigates a sentence of imprisonment does not detract from this. And so it was said as long ago as 1912 in the Whittaker case by Ines CJ, that which we quote in our heads, that sorry, I'm trying to rush so that I meet the 10-minute promise.
This is the statement, the famous statement.
The famous statement of the residual principle. Correct. You'll find that
repeated in this court a number
in many courts, and even in the Constitutional Court. Yeah. You'll find it on page 12 of our heads 52.1, paragraph 52.1. It said about the prisoners, they were entitled to all their personal rights and personal dignity, not temporarily taken away by law, or necessarily inconsistent with the circumstances which they have been placed. And then in the Fambilion case, on the Constitutional Court, it says, once it is established that anything less than a particular form of medical treatment would not be adequate, which is the second reason that my learned friend Mr. Mpatlele omitted to mention to the question from the bench, where the court was saying, we know that they considered it, but why did they reject it? One of the reasons why they rejected it was the fact that, according to the reasons, it was clearly stated by the head of the prison, Ms. Khadebe, and by the military health services, that there were no facilities in any prison in this country that can cater for this particular patient. But I'm coming there. The prisoner has a constitutional right to that form of medical treatment, and it would be no defense of the prison authorities that they cannot afford to provide that form of medical treatment. What is adequate medical treatment cannot be determined in vacuum. And lastly, before we take the break, I want to read what the Constitutional Court said more recently in Sonke Justice. And it said this: all rights in the Bill of Rights apply to inmates, save where justifiably limited in terms of Section 36 of the Constitution. There are, however, a number of non-derogable rights, one of which is Section 12 rights, that become especially important when an individual is incarcerated and thus directly subjected to the state's coercive powers. These include the rights to dignity, life, freedom and security of the person, and to be detained in conditions that are consistent. This part is a direct lifting from Section 35(2)(e) of the Constitution. And to be detained and in conditions that are consistent with human dignity, which include opportunities to exercise and the provision at state expense of adequate accommodation, nutrition, reading, material, and medical treatment. So, without that starting point, with the greatest respect, we will never understand the purpose, a la purposive contextual interpretation of either Section 75.7 or Section 79.1. These are not just tick boxing things. Yes, there is a purpose, and that higher purpose is the protection of, is to make sure that somebody in the shoes of Mr. Zuma is not allowed to die in conditions which are not ideal as determined by medical experts, or purely because we hate him, or purely because he was guilty of contempt or whatever is being alluded. He, like everybody else, is entitled to the protections that are afforded by our Constitution. And the day that medical experts say that this man is terminally ill, medical experts that are registered with the HPCSA, who have taken the Hippocratic Oath, and we say, what? No, we don't think he's sick enough. A doctor, how can a court of law, or me, or any of my learned friends, know better than medical experts? Nobody has said that they were bribed or they belong to some faction or whatever. These are experts who, in respect of whom we must assume that they've discharged their professional duty. And they say the man is suffering from a terminal disease. And who are we? Who are we to say no? Simply because of some flimsy argument that is now stable, quote unquote, whatever that means, in a hospital setting. And that is my last submission, Justice Dambuza, but it's squarely answers the question you put to Mr. Patel, namely that the reasons why the National Commissioner rejected the recommendations, so-called, of the MPAB are well articulated. They are, one, that they simply don't have the facilities. Maybe they should, but they don't have to accommodate him. Two, apart from the facilities point, is the fact that he presents, and this is where the criticism which really gets to me. Because what my learned friends then say is that no, in that articulation of reasons, which are in paragraph 12, I won't go there now because of time, paragraph 12 of the reasons, where he says, but, says Mr. Fraser, but the very reason that he is stable is because he is, as we speak, sitting in some private hospital in Pretoria. That private hospital in Pretoria is not the same thing as the escort facility. And we cannot keep him there forever, for 15 months in that private hospital. We simply do not have the facilities to cater for what is said in these reports. And therefore, the MPAB cannot be, its view, important and many and plentiful as they may be, cannot override the expert opinion that he is suffering from a terminal illness, which is the jurisdictional fact, which is the fact of life, which is nobody in this country can say the man does not suffer from a terminal illness when Dr. Mafa and Dr. Mphato say so. That's the court.
Thank you. We'll take the lunch adjournment until 2 o'clock. Thank you, Mr. Mbofu.
Thank you, Justice Tambuza. Excuse me. If I may, with the leave of the court, before dealing with Remedial, just sweep on one or two issues which I just wanted to highlight, and I won't take even 2 minutes on them, because as it was correctly pointed out, I have another bite in reply. But just so that my learned friends can have an opportunity to address those points, instead of me raising them or springing them in reply. The first one is related to the question that I was addressing, which is related to the issue that was raised by the presiding judge on this issue of the motivation. In other words,
the amendment.
The motivation in the reasons. Remember, you put this, my lady, to Mr. Mpahlelo. It's not sufficient, and that is correct. It would not be sufficient for Mr. Fraser simply to say, I took into account the recommendation of the MPAB. Mm-hmm. We must know, and the court must know, as to why did he, I think the word that was used, reject it. Might be a strong word.
If he did.
Yes, if he did, yes. And I just want to address that point, and then I'll just go very quickly again to the issue of the jurisdictional facts. I'll just touch on it. The answer is this to the first question, to Justice Tambuza's question. We have to accept that public officials who are clothed with administrative power, and at that discretionary administrative power, have by implication a certain status, for lack of a better word, in relation to that. So if the person is in Department of Water Affairs and they are the ones who are going to decide water licenses, it doesn't necessarily mean that they must be experts in fishing in the true sense, but they must know sufficiently to be able to grant this one a license and refuse this one a license and so on. Now, if we start from that premise, then we need, it is a crucial point, we need to be able to distinguish between those matters that fall exclusively within the expertise of experts, and those matters about which that official knows sufficiently to say yes or no to this and that. And let me explain what I mean by that in relation to this case. If you go to page CB42, Mr. Fraser goes to town giving the motivations as to why he has quote unquote rejected the MPAB's recommendation. He says 12.1, he says, I've taken inter alia, the following to come to my decision. One, Mr. Zuma is a 79-year-old, now 80, and undeniably a frail person. If I can just pause there. Mr. Mpahlelo is quite right. That must have a bearing, for example, on the 79(1)B issue, as to the propensity or the ability to re-offend. And I accept the proposal put by Justice Tambuza that it is not a black and white thing. It doesn't mean if you are 100 years old, you are incapable of offending. But remember that the yardstick in section 79(1)B is simply to say the propensity to re-offend must be low. It doesn't say it must be non-existent. And in my respectful submission, it is a factor, the age is a factor. The community, Mr. Fraser, in his answering affidavit to, I think it's page 894, in his answering affidavit to AfriForum, says that there was also, in the kind of community that he was going to be living in, the propensity or the possibility of offending would be low. So, and I accept, again, your ladyship's point that this is a mixture of reasons that are put here in the reasons, but also some of them in the answering affidavit. And simply to say it is allowed to put reasons. What we cannot do is to manufacture new reasons, but you can put or expand on your reasons in reply, I'm sorry, in the answering affidavit. Then it says that the various reports from SAMS all indicated...
Sorry, Mr. Bob, you say you can put or expand.
Yes, you can put
in your...
Yes, it's
in the litigation.
In fact, yeah, I heard this I was on the other side of that debate where I was saying you can't just come up with, even if there are good reasons in the answering affidavit. But the court found against me on that point to say that, of course, there's a difference between what we all know, so-called ex post facto rationalization, which is not allowed, than putting reasons which in a way operated at the time but might not have been articulated either at all or sufficiently in the stated reasons, because as I said, reasons by their definition are a summary of the reason. So the next point is, then they say that the various reports, I don't think there's any debate about section 79(1)(c) because it's catered for. They say that the various reports from SAMS all indicated that Mr. Zuma has multiple comorbidities, I think it's a misprint, that, which required him secure specialized treatment outside the DCS. Please, let's flag that because I'm going to come back to him. And then he says at 12.3 that Dr. Elm Patswe, in his report dated 23-21, recommended that the applicant, Mr. J.G. Zuma, be released on medical parole because of his clinical health, present dictated health conditions, and sufficient evidence has also arisen from the detailed clinical reports submitted by treating specialists to support the above recommendation. Let's pause there. So this is what I meant by when I said Dr. Mpatswe might not as expressly as Dr. Mafa have said that there is a terminal disease. But if you read properly what he says, he's exactly saying that. Why? One, Dr. Mpatswe is a member of the MPAB. So we have to assume that he knows that the gateway requirement for recommending parole, medical parole, is terminal illness. So when he says there are sufficient reasons from what I have seen to recommend, surely, unless if we are going to be nitpicking and say, no, but he should have said it in so many words. Obviously, that's what he implies. But as I say, we don't even need that mental exercise because Dr. Mafa actually does it expressly. Then it says the medical board, and this is the important one, 12.4. Medical Parole Advisory Board, and this comes to your question, Justice Dambuzi, where he now explains why he rejected, quote unquote, the medical says agreed that Mr. Zuma suffered from multiple commodities. The MPAB further stated that this treatment has been optimized and these conditions have been brought under control because of the care that he is receiving from a specialized hospital. Now we concede, as our learned friends point out, that the words because, those are not verbatim quotations of what the board said. The board simply said that the conditions have now been stabilized. But it follows as a matter of logic that those conditions which had deteriorated at Escort Center had been stabilized. That's exactly why he was transferred to the hospital. Had been stabilized because he had been taken to a private hospital. And now, here's the crucial point. Just as we can say, unlike the other side, because they are wrong when they say nowhere is it said that he has terminal illness. I've demonstrated that. But we can say nowhere is there any report that says he does not suffer from a terminal disease. Nowhere. That, and I'm prepared to concede once again, that it might be an implied meaning, what have you. But there's nobody, not even the MPAB, says it does not. They simply say his conditions. Please remember those words. So we are entitled, with the greatest respect, to put the following word in bracket. The MPAB further stated that his treatment has been optimized and his terminal conditions, remember the debate we had about the meaning of the conditions, and his terminal conditions have been brought under control. Now, what would be wrong with that? If they say, and again, I'm not going to go to war to say that is I'm just saying that is one of the acceptable readings of that statement. Now, if that's really what they were saying, then why are we here? Because all they were saying is that, yes, we've seen this report, yes, he is terminally ill, because I've never heard that terminal illness can be unterminalized.
So are you reading from the
12.4?
Oh, not the decision itself.
No, I'm reading for the reasons, my lady, which is CB 42. I'm sorry, I didn't give the page reference. CB 42. I'm reading from the reasons. Everything I've read so far is from the reasons.
Oh, okay. I also thought you were referring to the decision.
No. I'm sorry. It's my fault. I should have made the reference to CB 42. So CB 42. That's the actual reasons.
Okay,
all
the
I'm
question
saying,
I wanted to ask, sorry, Mr.
I'm sorry.
What I wanted to ask is,
yes,
why should we read between the lines? Because this is a crucial statutory requirement,
yes,
and it's a nub of what is supposed to be shown. Why should we be inferring and reading between the lines instead of it being categorically stated that this is the situation,
okay,
this is the terminal illness?
Yes, I understand that. Okay, then don't read between the lines. But if you don't read between the lines, it can be cut one side but not on the other side. Then let's not read between the lines in the MPAB. Let's not read between the lines with what Dr. Pato is saying. Forget what I just said to you. Let's forget about reading between the lines. What are we left with? The express statement of Dr. Mafa, who says there is a terminal disease. So it's not going to, I'm happy with that, because 2 minus 1 is 1, but 1 minus 1 is 0 on their side. So if we say forget about implications and what have you, then fine, we're left then with the express statement of Dr. Mafa. So I won't belabor the point, but at least in my submission, I'm saying this statement is equally capable, and that's all I'm prepared to say. I won't take it higher than that. Is capable of being read as follows: that his terminal disease or condition have been brought under control, and all the National Commissioner is saying, he's saying, yes, I'm not quibbling with you, MPAB. They've been brought under the control, but why? Simply because he's in a hospital. And the real point, big point I wanted to make, Justice Tambuza, is this. That's why I made that preamble at first. This is a matter of logic. It's not a matter of medicine. So you don't have to be a medical expert or to have an MBCHB to know that if somebody was deteriorating in a particular setting, then they get taken to another setting, and then they stabilize. Then if you take them back to that setting where they were deteriorating, they are likely to deteriorate. That's just a matter of logic. You don't need a degree for that. So the National Commissioner is capable of making that decision. It doesn't have to be a doctor or a lawyer or anything for that matter. It follows. If I take you from A and you are suffering, and I put you at B, if I put you back,
so
the likelihood is that you will.
You say we must understand him to be saying his terminal conditions have been
under control.
Put in terminal in
yes.
Okay.
In brackets, yes. And as I say, I'm not going to go to. It might be that he's saying his conditions, as I've seen in the redacted place. I mean, we don't know what's in the redacted areas, but I'm simply saying it is equally capable of being read in this way, given the fact that Dr. Pato, who's a member of that board, who knows the law. We can even say Dr. Mafa, maybe he deals with it. I don't know what his experience is. But Dr. Mpatwe is a member of this board. It is bread and butter. Every day he deals with this issue of terminal illness. And he says, release the man on medical parole.
Okay. Your 2 minutes is now 10 minutes, has grown to 10 minutes.
Okay.
I think let's wrap it up. You did make some of these submissions before lunch.
Yes. 12.5 I won't read out, but he also emphasized on the word conditions. In other words, to say those conditions would not necessarily remain under control at the escort center. And then the rest of it deals with 79(1)(c), that he will be released to the care of his wife and so on. So that is the point. The other point is that, well, I think we've already covered it in that little exchange with Justice.
Yeah, I think you did.
Because it goes to this issue of the jurisdictional fact. And I'm saying, forget everything else, Dr. Mafa. All right, now, as far as the remedy is concerned, and I'll be very quick.
And also the part of it you've already put into your earlier argument.
Yes, I'll only deal with the so-called no counting rule. I won't deal much with the TRANCON issue because I dealt with it when I was answering Justice Hussain.
That's paragraph 5 of the order, is it?
Paragraph?
Paragraph 5 of the order.
Of the order, that's correct, Justice Plaskett. Okay, I have a note here. If I don't read it, I'll be... It makes a quick point, simply that it goes back to that issue about who should be blamed for the reduction. It simply says that the confidentiality was a lawful claim under Section 10 of the Constitution, dignity, medical information, health information. We all are entitled to the privacy of our health information. And if there was a feeling that it was being abused, then
let's not go.
The courts are open. Okay, thank you.
But Mr. Mpofu, I don't want us to go back to that debate, but in terms of Section 79(4), yes, a person who applies for parole must give away their right to confidentiality. Is that not so?
Yes. Oh yes, Justice.
It says he or she must consent to allow the disclosure of his or her medical information in order to process an application for medical parole.
Yes.
Now, where does that end?
Yes.
In the parole process itself, he or she must consent to that.
Yes.
And we must accept that it must go all the way even to a review process.
No.
Where does it end?
Yeah.
And why does it end?
Thank you very much for that question, Justice Mahoka. I respectfully disagree with the fact that it is an endless piece of string. Let me explain why. Surely, if I decide to forgo my constitutional rights, and I want to forgo them to my learned friend, Mr. Masuku, that does not mean I'm also extending them to my learned friend, Ms. Kofa. Because it is clear from Section 79(4) that the waiver of rights, in fact, it's actually a quid pro quo. You are in a corner. They say, if you want parole, then you have to give that consent. So it's almost with a gun in your head, but I'm not emphasizing that point. But you are at the very least, at a neutral level, waiving or conceding those rights to medical doctors, to the MPAB, maybe to some correctional services people, and certainly to the National Commissioner, right? But how can that translate to you waiving the confidentiality rights to your medical information, to your political rivals, to busybodies that are are trying to get you back to jail or to the taxi association down the road or whatever. It can't.
But perhaps, Mr. Pofu, I mean, some might wish to contend. I mean, this forum, for example, and the Court à Quo, is certainly not a taxi association.
No, absolutely.
So why not to a court called upon to adjudicate the lawfulness of the decision?
There's something called a judicial peak.
Yes, absolutely.
What's wrong with a judge seeing that part of information?
Yes, the answer is nothing. But that was never put on the table. What we were told is that there's going to be a regime, a confidentiality regime, where the lawyers will look at the information. The lawyers of the DA, AfriForum, HSF, and any other letter of the alphabet that is on that side of town. So all I'm saying is that the waiver, Justice Mahoka, surely is at the hands of the waiverer, if you know what I mean. So if the waiverer says, yes, I'm waiving this to my daughter, as I must, because otherwise I won't even be eligible for parole, that can never be, can mean that I'm waiving it to all and sundry. That at least we accept. Now let's come to the issue of the judicial peak. The court would have been entitled, or in fact these parties would have been entitled, it goes back to the earlier point I was making, to say, okay, you got us. We can't invade your confidentiality rights. But we're going to go to court and say this, that you are overdoing this protection of your right. And we will go to court and ask for three things. Prayer one, that you give us the unredacted record. Prayer two, alternatively to that one, that the lawyers and all sorts of people will sign confidentiality agreements and they'll look at it. Further, alternatively, prayer three, there'll be only a judicial peak and no other. That's what they forewent. They themselves.
I think you've made that
as
point.
the court listens.
Yeah.
Thank you. Right now, to go back to the issue of and that's why we put it. Maybe it's again abuse of Latin, but we in our heads we say that we use the volenti non-fit in urea. In other words, they with their eyes open did not assert those rights. Okay. Now, if you then go to remedy, and I'll be very quick, I promise. I've already asserted that the Trancon test is not passed by any stretch of the imagination. None of the four requirements in Trancon have been met. The court is not in the same position as the decision maker. There's no fait accompli. There's no bias on the part of the current National Commissioner. There's no bias alleged at all. In fact, even in so much as bias is alleged, as far as Mr. Fraser is concerned, is concocted and made up, because he was once a DG when the President Zuma was a president. As one of my juniors pointed out, actually it was President Zuma who signed the act that we are debating here. So those are just coincidences of life. But let's assume for a minute that there's some half-baked case of bias against Mr. Fraser. That does not apply to the current National Commissioner, certainly. And so there's the issue of delay also didn't. That's why the matter was urgent. If you remember, there's another irony about the urgency. The HSF, even the HSF that was saying don't count the thing, they were saying no, but it's urgent because his release date is in October. Because they also didn't even believe in their heart of hearts in this other remedy of not counting. Because that remedy is just wayward and has no place in our law. You cannot say, in the face of what is said in Pasha, that parole is a form of punishment. Then we say don't count the 10 months or so that has now elapsed as we speak here today.
Good. Here you have punishment that was served de facto. It may not have been, if we find that the commissioner misdirected himself, it may not have been a de jure punishment, but it has been served de facto.
Absolutely.
And this puts a line through it. And I would imagine it may become relevant if it got to this, that where Mr. Zuma has to go back and then applies for ordinary parole.
Yes.
And at that point, the commissioner may have to take into account how he served this de facto parole.
Okay.
And it seems to me paragraph 5 may cut across the separation of powers there.
Absolutely. And for that, Justice Plaskett, just as a matter of coincidence, I will read the following. That the constitutional principle, the thing about substitution, by the way, is you've hit the nail on the head, Justice Plaskett. The problem with it is separation of powers more than anything else. Because as you, Justice Plaskett, said in this case that I'm about to read.
Oh dear, you're in dangerous territory there.
Yes, that's Interlude 2, PTY Ltd versus MEC for Roads, Public Works, and Eastern Cape and another. 2008-1, all SA 142 bracket CK. And you, Justice, with respect, Justice Plaskett, said this as far back as 2007 in a full bench decision. That at paragraph 44, you started to say you're acutely aware that the losing tenderer would feel hard done by because it was not he or she was not going to be basically getting the tender. And then you say, courts are furthermore duty-bound to respect the separation of powers, an important pillar of the Constitution. Indeed, administrative law is, this is now paragraph 45, in itself an incident of the separation of powers. A point made in the following terms by Chaskalson in Pharmaceutical, and then puts the well-known citation. Then Justice Plaskett then said, these constitutional principles mean that courts, when considering the validity of administrative action, must be wary of intruding, even with the best of motives, without justification into the terrain that is reserved for the administrative branch of government. These restraints on the powers of the courts are universal in democratic societies such as ours and necessarily mean that there are limits on the powers of the courts to repair damage that has been caused by a breakdown in the administrative process. And then it goes to the facts of that case. Now, in a nutshell, what does that say? It says that, firstly, we all know that substitution in itself is an exceptional thing, and we're saying there are no exceptional circumstances. But secondly, the court cannot arrogate to itself with cocky-penned documents in front of it the right and power to substitute a decision which was taken by a person with uncocky-penned documents. One. Two, the other issues that are raised by Mr. Fraser belong squarely in his terrain. When he says, the court doesn't know whether Mr. Fraser is right or wrong, when he says there's no prison in this whole country that has the facilities to cater for Mr. Zuma, we must assume that he's correct, because that's his work, that's his job.
And I suppose it probably is. I don't think there's anybody who quibbles with that as a matter of fact.
Absolutely.
And the point of departure becomes whether that's a criterion or not. Whether that is one of the jurisdictional factors or not.
No.
Well, that's going back to
no, that goes back. It goes back to the merits. But you are quite right. No, it's not about the jurisdictional facts anymore. It's now about the reasons, the rationality of Mr. Fraser saying, okay, he's stable now, and you are giving him to me. What must I do with him? It's no longer about the jurisdictional facts, but it's testing the rationality of his own logic, which he has displayed to the court. And there's nobody who can fault. For example, my learned friends here say, oh, well, it means he's getting preferential treatment. And I know Justice Platt said we must not go there. But the reality is that you and I, not all of us have got 24-hour medical service because we are ex-presidents. He does. And therefore, that is a fact that Mr. Fraser is entitled to take into account, because he's not just dreaming it up. He, as reports from the medical health services, the military medical health services, and he says, here is a person who is, unlike other citizens, has the luck to have 24-hour medical care. Why is that not a factor to be taken into account? It is. And it's
why is it that not, that's not then what the applicant, Mr. Zuma, sought? Well, if that's what he's entitled to, why doesn't he demand it from the hospital? Say, I need 24-hour medical treatment or attention of this. We don't know what the response would have been to that. And if I recall, there seems to be something that alludes to the fact that he did have some 24-hour medical attendant.
Yes, but your ladyship will have to go to the affidavit of the head of prison, which Ms. Nombubelelo Precious Hadebe, which you'll find at page 985 at volume 5.
Before you talk about that affidavit,
I'll just put a finger.
What just struck me about that affidavit is a system which expects an elderly person to do all the things that are supposed to be done, to clean, make up your bed. That struck me.
Yes, it is striking, Justice Mahalo.
And then you use that as sort of, I don't know, but it just struck me that an elderly person like a 79-year-old person, of course a 79-year-old person needs assistance. You can't expect a 79-year-old person to clean around and make their beds. That's why we care for them.
Like a 20-year-old.
That's why we care for them.
Yes. Thank you very much, Justice Mahoka, because this is one of those things where they say it cuts both ways. You see, that point is crucial, because those are the imperfections of our correctional system. But c'est la vie, that's what it is. In other words, so if those are the exact conditions to which Mr. Zuma, according to the respondents, is expected to be returned to, we might criticize those conditions, rightfully so. As I'm assuming you are in posing that question. But that's what they are. So that's the one thing. But the most important is that this head of prison, who has not been found to be lying or making up stories because he has some motives, says the following at 988 Mr. Zuma, there's a part that's illegible at 988, so it's printed more properly on 988A. She says, Mr. Zuma was subsequently transferred to the Pretoria Heart Hospital on the 5th August 2021. It should be noted that according to SAMS, that's the military people, the condition of Mr. Zuma required that he be under care of a medic on a 24-hour basis, a situation that was not possible at the facility, as the correctional center can only accommodate inmates overnight. Therefore, the medic could not be allowed to spend 24 hours with Mr. Zuma, as the medic could not be accommodated in the correctional facility. Again,
just remind me, Mr. Mpofu, just remind me, how is this now related to the relief?
No,
I think I've just lost you somewhere.
No, I understand, Justice. It's related in the following manner. The question that was posed, I think by yourself or one of the justices, or just by yourself, Justice, was that these issues that are raised by Mr. Fraser in CB 41 and so on, in the reasons, are they part of the jurisdictional facts? And my answer was twofold. The first part was to say, no, they're not part of the jurisdictional facts, because these are not medical issues. These are issues that lie in his terrain as a DG or Commissioner of Correctional Services. He and nobody else will know, and that's the point that I was having the exchange with Justice Hussain about. He and no one else will know if indeed there might be some facility in Kokstad or whatever that could have accommodated this situation. But he says there is none in South Africa. We just do not have that, and we have to believe him. Secondly,
so there's no point in the substitution order?
No, there's certainly no point in the substitution order, because it's a separation of powers point that I'm making. Because to do so would be to second guess the head of prisons when he says, I do not have a facility in this country to accommodate this person. The court says, no, you do. We'll take him back. We don't care that you don't have a facility. Let him die tomorrow. No court of law or justice can do that, because the court would then be saying, well, let's throw him to the wolves. The authorities of the people who are dispensed with this discretion say we cannot accommodate him, and the court says no, we don't care about that. We'll make a plan.
Is parole under those circumstances the only option? Because what you have also.
That's no, but you see, Justice Mahoka, that's.
Are you anticipating what I'm saying?
No, okay.
Okay, can I anticipate?
Right. No,
okay.
No.
What you have as an alternative is to keep the offender in a facility that allows for that care.
Correct.
Somewhere it is raised as a cost issue.
Yes.
I don't know how relevant that is.
It's relevant. To two answers. Let me start with the one, and I apologize. I thought you were finished, Justice Mahmoud. Let me start with the first one, which is a matter of law, before we come to this. In our law, a court is not allowed to ask that question for the purposes of review, because it has been said, and I don't want to go to the textbook now, a review court should not say, was there another way in which this could have been done? No.
No, but then you go back to the jurisdictional factors. You go back to the jurisdictional factors.
Accept that, Justice Mahfoud, but let me just develop the point. I'm saying a review court such as yourselves has the following duty and the following duty alone. Was the process that was followed by this functionary rational or irrational? The mere fact that the functionary could have done 20,000 other things equally good is irrelevant to a review court.
Maybe let me rephrase my proposition to you.
Right.
is this a review aspect or is this a treatment aspect?
Okay.
Because if it is a treatment aspect, it's got nothing to do with parole. It's got nothing to do with parole. It's got everything to do with how we care for this offender.
My answer will be it's both. And let me explain why. Yes, it's a treatment issue, that goes without saying. But it's a review issue in the following sense, which my learned friends try to do. They say, one of them says, I think it's the HSF, well, they could have kept him in that hospital. They could have probably built, I don't know, a kiosk or whatever for the medic. Fine, maybe so. But that's not that's the point I'm making. As a matter of law, the review court is not expected to then look at all the possible things that could have been done and say 5 of them are good and another say. A review court's strict duty is to look at what actually happened and look at it and determine the rationality thereof on its own 4 legs.
Mr. Mpofu, I think the point that's being put to you is along these lines, that medical parole is quite narrowly defined.
Correct.
And the factors that apply are quite narrowly defined, the 3 factors essentially.
Yes.
If Mr. Zuma doesn't qualify for medical parole, but still needs that treatment which the prison service say they cannot give, that's not the issue before the review court.
I get the point.
And it is, as my brother says, a question of treatment.
Yes.
Making a plan to get the treatment for that particular prisoner.
Absolutely. I apologize, Justice Mahok. I get the point, absolutely. The answer to that point is very simple. If Mr. Fraser was coming to you, and Mr. Mpahlele was again at pains to point this out, if he was coming to you and saying, or to Justice Batojane, and saying, you know what, I, Arthur Fraser, accept that there is no terminal illness. I, Arthur Fraser, did not read the words of Dr. Mafa saying that there is. I, Arthur Fraser, did not read Dr. Mpatso. The only thing I'm saying to you, court, is that I don't have facilities. That's a different case altogether. No, this is not what is happening here. The man is saying at 8, I have read the medical reports of 3 people. I've read Dr. Mpatso and so on, and I've read the recommendation of the MPAB. And on top of that, I don't have the facilities to house this person. That is a completely different situation to where, and I now understand the point, where he would be saying, and now I understand the formulation of Justice Bahoka, they're saying let's separate the treatment issue from the jurisdictional fact issue. But here, on the facts before this honorable court, the primary reason that is being granted is the existence of a terminal disease. But he then says, in this genre of a terminal disease, which also requires 24-hour medical care, I don't have the facilities in any event.
Well, if he's correct,
I'm sorry.
If he's correct on the terminal disease, he doesn't need that bed. If he's correct on terminal disease,
yes,
he doesn't need that which you are saying now.
Yes, but then that's a point in my favor. Because if he doesn't need, if he has 8 reasons, but he only needs 2 of them to succeed, well, that's his lucky day. So and I actually accept, I have to embrace that point.
Because in terms of the Act,
yes,
if there is terminal illness and all other jurisdictional factors are there, then the commissioner is home.
Yes. No, absolutely. As I say, I don't want to look a gift horse in the mouth. So I accept that without any qualification. and that he, to the extent that he might have had surplusage and put more reasons than what is necessary, well, it just shows how good he is. But the point is, and I accept it without qualification, that the ticket to the game, we all, the whole morning and part of this afternoon, all agree on one thing and one thing only, that the ticket to the game is a terminal disease. Without that, all these things, whether, and that ticket to the game is, it must be illustrated in the following way. Let's assume the medical parole.
Before you go into that, Mr. Mpofu, we are now at 22-3. We still have 4 parties to argue. So I will give you the last 5 minutes, and that's it. Okay, don't say you'll take 2 because you've said that before. So I'll give you the last 5 minutes. Use them as you will, and then we will go to the respondents.
I'll do this.
I don't know whether this may assist, Mr. Mpofu, because I mean, I think that the bulk of your argument has been establishing the ticket to the game.
Yes.
Well, let's assume for the moment that we are not with you, and you don't get the ticket to the game. Then we're in and having to deal with remedy, which is, I thought, where you were actually going, but we went back to the merits.
Well, I was asked
so can I ask you then just to address a few aspects of your notice of appeal?
Yes.
Because in your heads of argument, all you ask for is the dismissal of or that the order that should be substituted, appeal upheld, and dismissal of the court en quo. But in your notice of appeal, you frame rather different relief. So the question is, are we going along with the notice of appeal because something quite different? This relates to paragraph 5 of the order, which, as my brother has indicated, notionally may offend the separation of powers. Let's assume that that argument is accepted. In other words, that the court en quo should not have granted the declaration that the time spent out should not be counted, on the basis that such an order offends the separation of powers. Would you agree that the converse order equally offends the separation of powers?
Namely?
That the time spent out should count.
No.
Why not?
It can't, because that follows as a matter of law. If we accept as a principle that correctional, or rather medical parole is a form of punishment, then the affliction of the time spent follows ex lege, number one. Number two, its onerous impact is irreversible. So the idea, actually, it's so repugnant. This would be like this court sentencing afresh Mr. Zuma, because remember, he has a release date called 7th October 2022. That order makes the release date to be, I don't know, 24th of May 2023.
Right. So I understand those submissions.
Yes.
And I think we've heard the basis.
Thank you.
That's the basis for your paragraph 6 in your notice of appeal. That the time served while on medical parole must be taken into account.
Yes.
Correct. Is there any need, and is there a basis for consideration of paragraph 4 and 5 of your notice of appeal? In other words, this is on the basis that you haven't got the ticket to the game, the matter is remitted, we accept your argument on the substitution points, it goes back to the National Commissioner.
I see. No, Justice Hossain, the answer is no, and there are two quick answers to that. One, remember that paragraphs 4 and 5 were raised in any event in relation to section 17(1)(a) Roman 2 of the Superior Courts Act, which is under the all-encompassing other compelling reasons. Yes, but if we forget about that for a minute and go for the hardcore section 17(a) Roman 1 appeal, grounds of appeal, then the submissions that I've made would be sufficient. Secondly, The issue of, I know you're saying I must assume that the ticket for the game is not there.
For argument's sake, for purposes of remedy. Yes.
But I want to flip that, and this is my last submission, to say that if, as I respectfully submit, we have demonstrated that the ticket to the game was there, then this court does not even have to bother about these issues about substitution and counting or not counting or whatever. That then it really becomes superfluous. But in the unlikely event, or in the event, let me not be too optimistic, in the event that the court finds, despite all the evidence, that there was no terminal disease, then the court will be constrained in the light of PAHLA, in the light of the residuum principle, in the light of all the principles that we have spoken about, to say that and to say that the relief in both its legs of substitution and the so-called no counting is draconian. The first one is impermissible because the Trancon rules have not been met. The second one is simply draconian because it amounts to is sentencing Mr. Zuma to a sentence, a new sentence. So he must now serve 15 months in custody plus 10 months in the current situation where he can't travel, he can't address meetings, he can't, he has to ask for permission to do this and that and
he was under parole
for 10 months.
And with all its attendant.
Absolutely, which is punishment.
He was serving a sentence.
He was serving a sentence.
He's serving his sentence. The PAHLA makes it clear he's serving his sentence, so now we want him to serve a double sentence. On what basis?
Just for
when he's not, I'm very sorry, Justice Mabel. I just want to finish this,
no
this
problem.
point. That, remember, the only thing was sold for this is that he's not an innocent party. That is obfuscation. Because to say he's not an innocent party simply because he says that he was wrongfully arrested is pure obfuscation. He should be...
I think we'll hear the respondents on that.
Yes.
I mean, it's...
Yeah, he's an innocent party as far as the review, the parole issue is concerned, because he did not give himself parole.
Yeah.
And there's no evidence that he went to Mr. Fraser and said, you know, let's cook up this scheme and what. He is an innocent party. Okay. Why must he be punished? I'm sorry, Justice.
Okay, sorry, I just want the practicalities of your order. If the order is to review and set aside, consequentially, that means he should go back to jail, correct?
No.
Okay, just for that one.
Okay,
the consequences,
argument, yes.
Yeah, the consequence of that order is go back to jail. Then you're saying, despite that, this court should actually say no. The time that is served while on parole fulfills the sentence. Is that right?
No, I'm making two submissions, and one of them is the one you're making, Justice. The first one is that let's go back to first principles.
Yes.
The default position for a reviewing court is the remitter.
Yeah.
Okay? Mm-hmm. So if we accept that, the default position is to remit the decision to the decision maker.
Yeah.
Under certain exceptional circumstances defined in Trancon, the court may substitute.
That's right.
I've already addressed the fact that doesn't exist. So that's the first leg of what I'm saying. The second leg, which comes squarely to your point, is the following. Let's even assume that substitution was competent, which we reject. Mm-hmm. But let's assume for a minute that it is competent. It would be draconian and unduly punitive to mete out, to visit further punishment of 10 months of, because that's what it would amount to, further 10 months of parole conditions over Mr. Zuma. Without any trial, without nothing happened, just by the stroke of a pen, a court will simply say, your sentence has now been increased by that portion, let's just call it that little 10 months extra. That should offend the senses of anybody who lives in a constitutional democracy. Because what is that? Why? Why would any human being be subjected to such degrading and cruel punishment? Why? For what reason?
Okay, thank you very much, Mr. Mpofu. Mr. Zuma?
I'm indebted to you.
As the court pleases, Justices. Could I begin with an aspect which, if I understood my learned friend, in response to, I think it was Justice Makoka's question, he responded by saying that we forswore any attempt to get the court quo to have a so-called judicial peek at the unredacted records. That's how I understood his response. Now, with the greatest respect, and that's not correct. If I could ask, I'm beginning with this discrete point just to rebut that, and then I'll get into my submissions as such. If you go to volume 2, Justices, at page 242, para 3.1, the confidentiality regime was expressly put by my attorney, or the DA's attorney rather, to the state attorney and to Mr. Zuma's attorneys. You find that at volume 2, 242. And the regime was that only the DA's counsel were named.
Just, is it page 341?
No, 242, Justice. Volume 2, 242. The confidentiality regime that was put to Mr. Zuma's attorney and the state attorney for the Commissioner was that only the DA's counsel who are named, who are counsel here present, and one attorney at the DA's firm of record rather, namely Alzani Jonker of Minder, Shapira and Smith, and the legal practitioners nominated by the respondents, in other words Mr. Zuma and the National Commissioner, as well as the judge or judges hearing the review application, will be permitted access to the remaining portions of the record, i.e. the unredacted versions of the documents that are redacted in the non-controversial portion of the record, as well as the unredacted versions of any other documents that were entirely left out of the non-controversial portion of the record.
But that's now water under the bridge.
No, but it's just the response to the debate which ensued as to why, and to the extent that is supposed to go to remedy, and that we are the authors of our own downfall. Factually, I want to put that on record. That's not correct. And it was further said in 3.2 that no other person, including for the avoidance of doubt, the DA, any of its members, etc., or any members of the law firm other than Ms. Jonker shall be permitted access to the remaining portions of the record. So, with respect, that was not a correct answer. But to get back to, or to then commence with our principal submissions on behalf of the Democratic Alliance, our position, Justices, and some of what I have to say may be water under the bridge, if I'm not, Justice Plastic. But our position is that if you are with us on our principle, the DA's principal contention, which is that absent a positive recommendation by the Medical Parole Board, the National Commission had no power as a jurisdictional, as a result of there being an absence of an objectively determinable jurisdictional requirement as per Kimberley Junior School. If you're with us on that point, that's the end of this appeal. You then don't get, with respect, into the more tricky issue of an evaluation of medical evidence and whether or not there was, in fact, a positive finding with regard to terminal illness or condition and or physical incapacity. You don't reach that, because that's the end of the appeals. We submit.
Just a question. Mr.
Yes,
Mpofu says that you can't interpret, I don't know if it was Mr. Mpofu or Mr. Mpahlele, the Act doesn't express itself in the same terms as the regulation with regards to the recommendation being positive. And so you can't interpret the Act using the regulation. So you can't beef up what's not in the Act by reading the express provision of that regulation.
In fact, the Act makes no reference to a recommendation.
I was about to say, the Act...
What the Act seemingly does, it places the two medical reports on par. That is the first medical report by the doctor who makes the application, and the medical report on behalf of the advisory board. And the Act says that report is an additional report. So it suggests that the two medical reports are on par.
With respect, we would not agree with that proposition, Justice Parker. Could I explain why in a minute? But could I begin at the beginning of the... So the map that I was going to indicate for my submissions is we're going to deal with the legal framework. Then we're going to deal with the facts, mainly to be gleaned from the core bundle. We'll then deal with the reasons and demonstrate why, with respect, Mr. Fraser's reasons don't withstand scrutiny. And then, as a division of labour, I'm not going to deal, I may make some remarks about remedy, but I'm not going to deal intensely with remedy, because that will be done by Mr. Du Plessis of Helen Suzman Foundation. Given that we've not pleaded for the second part of the remedy, namely the non-counting part of it, as it were. So I cannot really make submissions and shouldn't make submissions in that regard. We support the submissions of the HSF in this regard, but I'm going to leave it to Mr. Du Plessis to make those submissions. We've also agreed to say, the three of us, AgriForum, HSF and ourselves, that if I need a bit more time, Mr. Pompofu, as is his wont, took the lion's share of the time. So we are now deep into the day. We will divide up the time between us, and we mentioned that to Justice.
We are aware of that.
So if I may proceed on that basis, if I can commence with Section 75, and I think this appears by now to be common cause. As we read Section 75, Justices, 75's purpose, there were two significant concessions made this morning, one by each of my learned friends. The concession made on behalf of counsel for the Commissioner was that let me just the concession made on behalf of counsel for the Commissioner was that, I think it was in response to a question from Justice Cousin, was that I'm jumping ahead of myself, if one goes to 79.2 Roman 2, he conceded that in the facts of this case, the application by Dr. Martha was made on behalf of Mr. Zuma. So that is a significant factual concession that was made this morning. The second concession that was made by...
Sorry, why do you say it was a concession?
I'm sorry?
Why do you say it was a concession?
Because he accepted
that the application was made by Dr. Martha on behalf of Mr. Zuma. Hasn't that always been the case?
No.
Oh, I thought it was.
I'll get to it. I think it's fair to say that they attempted to bring the application under 79.2a Roman 1 as one brought by a medical practitioner, full stop. Unless I'm misunderstanding the position,
I see.
the exchange between Justice Cousin and my learned friend for the Commissioner established, my learned friend for the Commissioner accepted by a medical practitioner, full stop, because those two scenarios are totally different, and it goes directly as to why there's a need for an independent medical report. But I'm jumping ahead of myself. Before getting there, those are the two. So sorry, that was the National Commissioner's concession. The concession on behalf of Mr. Zuma was that, contrary to the position in their heads, where they, and it was put to them by one of the justices, they advocated for a separate, discrete, independent pathway to medical parole via Section 75. My learned friend, I think, quite correctly conceded. You'll have a chance to address.
Well, there were paragraphs in the heads that seemed to suggest that well, to say explicitly this is an alternative route, but there are others that acknowledged the application or the consideration of the two sections together. So in that sense, the argument as a whole, had grey portions.
Well, Justice,
it was not very clear.
I've always believed in the dictum that you can be clearly wrong, but at least you should be wrong clearly. And if they can't have it both ways. They can't say in some portions of the heads that 75 presents a separate, discrete pathway in other parts of the heads that they accept it must be read together. I understood.
They accept that
they must be read.
That the jurisdictional facts that have to be established are those in 79(1) A, B, and C, as I understand it. So the debate was to an extent about the relationship between 75 and 79.
No, that's where.
But we've been talking about those jurisdictional facts, and particularly the one in section 79(1)A.
Can I just articulate?
And we're all on the same page about that. Those apply.
Thank you, Justice Plasker. Can I just articulate clearly what our position is? Our position is that there are no two. Certainly, the powers of a national commissioner are located in both 75 and 79. That we accept. But they do the two sections do two different pieces of work. 75, primary if not sole purpose, is to identify the actor. So, for instance, if you go to 75(1)A, it says the Correctional Supervision and Parole Board, having considered the report on any sentence offender serving a determinate sentence of more than 24 months, may A, place that sentence offender entirely on medical parole. So, that is the requirement, more than 24 months. If, however, the prisoner has been declared a dangerous criminal, and this is dealt with in B, sub B, then the parole board cannot place that individual, that sentence offender, on parole. It can only make a recommendation to the court. So that's the second actor. Then C, in respect of any sentenced offender serving a sentence of life incarceration, again, the parole board does not have the power to place that offender on inter alia medical parole. It can only make a recommendation to the minister. And then what follows after 1, from 2 to 6, are various provisions that are not directly germane to this case. And then we get to sub 7, which was relied upon previously by Mr. Zuma as being a discrete, self-standing route, as we understood it, to parole, medical parole. And that says, as you know, despite subsections 1 to 6, the National Commissioner may place under correctional inter alia medical parole a sentenced offender serving a sentence of incarceration for 24 months or less, which indisputably Mr. Zuma was and still is. So we have no difficulty with the notion that the National Commissioner, and we've never challenged that, the National Commissioner locates the source of his power to grant medical parole in 75 sub 7. We've also not quibbled with his explanation of the delegations that he made and how he took them back. Got no issue with that, we haven't challenged that. The issue was 79 and the application of 79. It now appears to be accepted, as it must with respect, that 79 provides the criteria and the process for medical parole. I see my learned friend is nodding. Mr.
Yeah, he did accept.
So I'm very glad that we're on the same page. Yeah, he's accepted. Now, once we accept that, a fair amount of the submissions I was going to make to you in this regard falls away. But I now want to then focus on the role of the Medical Parole Board. So Justice Hawker put to me that it appeared that the Act itself, Section 79, puts the report, if I understood you correctly, Justice, envisaged in 79(2)C on the same level as the Medical Parole Board's report.
Yes, that's what my colleague was putting to you. That it refers to the board's medical report as an additional it uses the term additional rather than any other.
As we read the sections, so I'm not going to then dwell on 79.1 because the point we were going to make is it makes it quite clear it's any sentence offender, and the introductory words to 79.2 is an application, and we submit those words just properly ordinarily construed cover the field. Any medical parole application can only be brought under 79.1 and 79.2. Doesn't matter, and that much is clear with respect from the reference to shall be considered for placement in 1 on medical parole bar, and then it mentions all the actors identified in 75 except for the court. So it's quite clear with respect that the medical parole system that is envisaged in 79 covers all the potential actors, the parole board, the national commissioner, and the minister who can grant medical parole. But that seems to no longer be in use. So if I can then go to, as I've said, the role of the medical reports in 79. Can I first ask the court to have regard to the fact that 79.2 talks about an application for medical parole shall be lodged in the prescribed manner. In other words, as determined by regulation. And we know that there is a regulation that's applicable. And then it provides for 2 scenarios. The one is, Roman 1, a medical practitioner, or 2, a sentenced offender, or a person acting on his or her behalf. And then in the case, B provides that in the case of a Roman 2 application, and in other words, a non-disinterested application. And this is the first important point we want to make. You can have an application in terms of Roman 1, which is brought by a disinterested medical practitioner. So in other words, where there's an external medical practitioner who's called in to examine one, or the prison doctor, the district surgeon, as we know, operate or tend and have clinics in prisons. That would be a disinterested doctor. That medical practitioner, could, after examining a particular patient in the course of a morning or afternoon clinic at a particular prison.
But where do we get disinterested medical practitioner from? The Act doesn't talk about a disinterested medical practitioner.
I'm getting there, Justice Bukwana.
Okay.
I'm attempting to provide you with an analysis. We submit the correct analysis of why B talks about and what the purpose of B is. So there are 2 scenarios in 2A. One is a medical practitioner, 2 is a sentenced offender, or a person acting on his or her behalf. The factual concession has already been made, and it's a fair factual concession by my learned friend for the Commission, that Dr. Martha was not acting with respect as a medical practitioner. He was acting on behalf of Mr. Zuma.
Can there be that distinction?
I'm sorry, Justice.
Can there be a distinction like that? I mean, if he's a medical practitioner, isn't he a one for all intents and purposes?
No, because if you are, the reason why there is a distinction, we submit, in B, and why only an application that is lodged by a sentenced offender and a person acting on his or her behalf in terms of 2 requires the sub-C medical report is precisely because of the need for there to be a further medical report in our submission.
Well, can't 2A1 and 2 be the same person? He is a person that is a medical practitioner, and he is also lodging the application on behalf of the applicant. Why do we need to split hairs about that?
Let's accept for the moment, Justice, if the medical practitioner who provides a report complies with C, in other words, if it deals with everything that C requires, which we submit just as a matter of common sense, would be the absolute basis, or the absolute basics for a medical report applying for medical parole. You have to deal with these things. And if the report deals with these things, then let's accept, for present purposes of the argument, that you have a medical report, you may not need, because we don't know what the nature of the application of a medical practitioner on its own.
Let's talk about this, what we have here.
Okay.
We've got Dr. Mafa. He is a medical practitioner. There's no dispute about that.
No dispute about
He is also acting on behalf of Mr. Zuma in submitting the application, okay?
Yes.
And then he says, I am submitting the medical reports that he did,
Yes.
right?
But yeah,
Yeah?
clearly the idea behind this differentiation is the offender himself or herself would ordinarily not be a medical person.
Yes.
And a family member or a friend
Yes.
would apply on his or her behalf would also not have anything to do with medicine.
Non-constat if it's a medical practitioner.
Yes,
Yes.
but a doctor, it is assumed, would have that information, having examined that offender.
Yes.
So it appears that's the purpose of that distinction.
Justice Mahoka, for purposes of the argument, I'm not going to, because due to time constraints and other matters, the more important point is the role. I accept that there's a bit of lack of clarity about the interrelationship between one and
But
two.
it is important for your not your judgment, for your argument, because of the presence or otherwise of an additional report. So I think you should make your submission very clear on that.
We submit that where the, and this is what the Act clearly says. So let me make my submission absolutely clear. If one goes back to 2A Roman 1, an application for medical parole shall be lodged in the prescribed manner by a medical practitioner, or 2, a sentenced offender or person acting on his or her behalf.
Could we stop at that first point and just, what is the prescribed manner?
The prescribed manner, Justice Curson, you find in Regulation 29A.
What does that say?
29A 2 says, an application for medical parole in terms of section, so it refers directly to 79.2 of the Act, shall be initiated by the completion of the applicable form as contained in Schedule B to the regulations. And then subparagraph 3, when a head of a correctional centre, now it becomes complicated as I'm going to demonstrate to you when I get to the facts. I think this may have been touched on already, but 29 capital A3 says, when a head of a correctional centre receives an application for medical parole, he or she must refer the application to the correctional medical practitioner who must make an evaluation of the application in accordance with the provisions of section 79 of the Act and make a recommendation in this regard. And then I keep on saying Roman, my apologies. Sub 4, the recommendation must be submitted to the Medical Parole Advisory Board, who must make a recommendation to the National Commissioner of Services. So that's the scheme of the regulations.
Thank you. I mean, the prescribed manner, what is prescribed, does that make any reference to what is set out in subsection C
of the Act?
Of the Act, 2C. In other words, does the prescribed manner mirror what is set out in C1 Roman 1, 2, and 3? From what you've read to me,
it doesn't mirror the language.
No. And the reason I ask that is because the contents of the written medical report, and that phrase strikes me as important, refers back to what is required when an application is lodged by the offender or a person on his or her behalf. And we know as a matter of fact that the application was lodged by Dr. Mafu on behalf of
I'm sorry, could you just repeat that, Justice? The application?
We know the concession, the factual concession was that Dr. Mafu submitted the application on behalf of.
Yes.
And so that would trigger 2B, which requires a written medical report. And then 2C specifies what that must contain.
That's correct.
And that is different to the application lodged in the prescribed manner. Is it not so?
It is indeed.
Yes. So, I mean, is that not the short answer to that interplay? So, in other words, if a medical practitioner, you posed the example of a disinterested medical practitioner, someone who examines the prisoner, for example, discovers that there is perhaps a need for medical parole, lodges the application, a 2-1 Roman A application.
Yes.
All that's required is that it must comply with the prescribed manner, which is the completion of the form.
That's correct.
It doesn't have to include the content of the written medical report in terms of 2C. Not so.
I accept that.
Yes. Now, Dr. Marfa's application in this matter, did it meet the requirements of 2C?
We submit it didn't, Justice. Personally. If you could ask you to go to Core Bundle 10, CB10. And this is why I indicated this becomes more complicated. As we read this form, or the documents that run from CB10 to CB14, which Dr. Marfa signs on 28 July, the document at CB10 is the application. That's the sum total of the application. And as you will see, significantly, under diagnosis, there's nothing, not even a redacted thing. So the medical report...
Doesn't it say see addendum?
It does.
Yeah, so what he chose to do was to put whatever the contents of his medical report.
I'm sorry, Joseph.
So what Dr. Marfa chose to do, rather than complete the report, was to attach an addendum, we can only presume, explaining the facts that are required under C of CB10.
Well, the difficulty with that interpretation or that approach or construction of what he did, Justice Lambuza, is that the addendum you will see is the document that begins at CB11, addendum to the medical parole application form. That's the addendum. And you'll see there that it says medical report. Now this is a different medical report. To be completed by the correctional medical practitioner in terms of regulation 29A3, which I've just read to you.
CB11.
Sorry?
That is CB11.
Well, it's CB11 all the way to CB14. It's the rest of, that's why I said, the only page of the application that we have is CB10. CB11 to CB14 is the addendum.
Yes.
And the problem with Dr. Marfa filling that out is that was supposed to be, in terms of the regulations, an evaluation of Dr. Marfa's application by the Correctional Services medic.
Yes.
And that's not what it is.
Yeah.
It's a document that Dr. Marfa himself filled out. And I think it was asked, possibly by Justice Mahoka this morning, how can you evaluate your own application?
Yeah.
And that is the difficulty. We've got an inchoate, irregular application, which is the foundational document of their case. This document, everything from CB11 to CB...
Well, that's not the case you make out, though.
I'm sorry, Joseph.
That is not the case you make out in the papers, in the record, in the founding affidavit that was before the court of court. No. The basis of the application was, or we did not have that as a complaint,
we
or
not,
one of the bases for the application.
I accept that entirely, but now that we've gotten into the matter and we're debating this and looking at these documents closely, the court has engaged our learned friend. That was put to my learned friend by one of the members of the court.
You see, though, CB11 is still an addendum to the medical parole application form.
Which?
So, CB11. is an addendum to the main application in terms of Section 78. It is not clear how many pages the application itself consists of. We only have page 1, which is CB10, and to which the addendum was attached. And then we have CB11, which is the addendum, the 3 pages up to
4 pages.
CB14. But there hasn't been a real complaint about the content, save for whether it constitutes what is required in terms of the Act.
I speak under correction. I do believe my colleagues for the HSF have taken the point squarely.
Can I just ask a question? Is this a substantive complaint? Is this a nub of your case? So that
No, it's not the nub of our case.
If it's not, then
Yeah.
It's a point raised by the HSF.
I saw it in passing that the provisions of the regulation were not complied with.
Yes.
That was the argument.
And I'm simply.
It might just distract from the centrality and thrust of your case.
No, it's not.
Yeah, does it matter that Dr. Martha filled in the wrong form? What he's done here by filling in this addendum is providing information that that motivates, as far as he's concerned, the application that he was bringing. So I really think we should get on to the real issues here.
Okay. Justices, can I then go to the... So on the basis that let's accept that the rest of the form is the information provided by Dr. Martha.
I think, Mr. Jamie, it would help as a starting point to go back to what my colleague Mahuka put to you or asked of you as to the meaning or the provisions of Section 79 3A and your submissions thereon. I think he said your case seems to be premised largely on the report of the Medical Parole Board being a be-all and end-all, if I may say.
That is correct.
Whereas Section 79 3A does not seem to say so, at least not in so many words. How do you get us to get there?
Okay, could I begin, and this was alluded to this morning, the genesis of the amendment to the Act to introduce the Medical Parole Board as being an independent body providing an independent report is set out in our heads of argument. You'll find it at para 35. And it's to do with the aftermath of the Shabir Sheikh case and story, and the need envisaged by Parliament to have the interposition of an independent body of medical experts to remove any temptation by the authorities to, and I'm casting aspersions at no one, but by the authorities to potentially want to favour with medical parole those powerful and connected in our society. That was the genesis of this amendment, to introduce that body. It accordingly makes sense, and there was some debate earlier from my learned friend for Mr. Zuma as to the fact that all that the board is supposed to do is provide a recommendation in terms of the Act. You will look at 79 3A and you will see there's no indication in express terms of the board making a recommendation. The emphasis is on the board, or the minister must establish a medical advisory board to provide an independent medical report to whoever's got the power to grant medical parole, in addition to the medical report referred to in subsection 2C. So that, in our submission, on a purposive, effective interpretation of the provision, makes it clear that the legislature elevated the purpose and importance of that report over and above the report in 2C, which in any event is only required if it's a sub-Roman 2 scenario, not a sub-Roman 1. That demonstrates, with respect, that you can have a medical parole application without 2C being complied with. And if that's the case, you can hardly elevate 2C to the same level of importance and centrality to the medical parole scheme as this independent board's report. So that's our first submission. Our second submission goes...
So does the board evaluate the application?
The offender or the application?
Does this board
yes.
evaluate the application that has been placed before the Commissioner and look at the...
It can do a number of
medical report that accompanies it, for instance?
Yes, that's one of the things that we do. But you would also know from...
And presumably, if there are things that on the face of the medical report don't cut it, the board advises the Commissioner to that effect.
Or the board may... I don't believe it's intended or that the board operates in a mechanistic, rigid fashion. These are all professionals, they're doctors, medical experts. So I would assume that if there's something not clear, or if they want to debate, or they would, as any reasonable professional would do, they would engage each other. But we know from, I think it's the regulations, Justice Plaskett, that the Medical Parole Board has the power inter alia to, I just want to see where it is, to seek a specialist, specialist input.
So it investigates the application that's been placed before
it
the
investigates the application, and then I just want to see. Yes, it's 3D. Nothing in this section prohibits a medical practitioner or medical advisory board from obtaining a written medical report from a specialist medical practitioner. So it's quite clear that the body is not a supine body; it needs to be interactive. And it's a body of, I think it's 10 people in terms of the regulations, 10 doctors. And
does it delegate one of its own
yes.
to do the work on his behalf, like Dr. Mpatswe did here?
In this case, it was Dr. Mpatswe, yes.
Did Dr. Mpatswe physically examine Mr. Zuma?
Yes. If you look at the core bundle, if you look at the core bundle at CB19, Justices, you will see Dr. Mpatswe's report, heavily redacted report. But at CB19, date of initial examination 13 August and date of reassessment 17 August. So it seems he saw him on at least 2 occasions.
Yes. So he examines him and he makes sort of a report or recommendation to his colleagues on the board, on the advisory board.
Yes. So, but the principal submission that we make is that Parliament saw fit, in light of a perceived weakness in the system, to put in place quite sensibly, we submit, an expert independent body to provide a report. And given that very deliberate decision by Parliament to amend the legislation, it cannot be said that that report that arises from the working of the Medical Parole Board is simply elevated to one of a number of factors that the Commissioner can consider, including a 2C report, which may or may not even be there, depending on who's brought the application.
And you say he's bound by that report and has to give effect to it, or has to...
I cannot say that on the basis of what the Act says.
Yeah.
Because the Act doesn't say that. But I can say it on the basis of what the regulations say. And I want to make it clear what our position is. We are not saying, Justice, we're well aware of the authority that says you don't interpret legislation by subordinate legislation. But I have 2 submissions in that regard. The first submission is this is not run-of-the-mill subordinate legislation simply made by the executive, the minister, or drafted inside the minister's department. These regulations, if you look at section 79(8) A of the Act, it requires regulations to be made for medical parole, and then B says the regulations must be submitted to Parliament for approval at least 1 month before promulgation if Parliament is in session, or if Parliament is not in session, within 1 month after the next ensuing session starts. So we fully accept that that is not the ordinary procedure for making law, which goes through, depending on the nature of the law, both the NCOP and the National Assembly. But certainly, these regulations are placed before Parliament for its approval, the very body that legislated the Act itself. So that's the one submission I make. The second submission is that it's not a question of interpretation of the Act. It's a question of applying all the laws that are applicable to medical parole, including the regulations, absent a challenge thereto. And there has been no challenge to the regulations. There's no complaint of lack of constitutionality, ultra vires, etc. So the regulations stand. And my learned friend, Mr. Mpofu, took you toward the end of his submissions to, I think it was 29A, 3 and 4. And he spoke in 4 about the double recommendation. But to the extent that he was referring to 4, you must take the regulations as an entirety, in toto. And again, whether this court doesn't have the power, as this case has developed, and given what the contentions are, what the disputes are, this court obviously cannot suo motu strike down this regulation. And the regulation I refer to is 29 capital A7. Because 29 capital A7 provides a positive legal obligation on, or rather constrains the National Commissioner's powers to the extent that it says, let me read it, the Medical Parole Advisory Board must make, and this is the first mention of recommendation, as I've indicated to you, 29.3 or 79.3A only talks about an independent medical report. We now have a recommendation, so this is expanded upon in the regulations. Must make a recommendation to the National Commissioner, the Board, etc., on the appropriateness to grant medical parole in accordance with Section 79(1)A of the Act. If the recommendation of the Board is positive, then the National Commissioner, etc., as the case may be, must consider whether the conditions stipulated in 79(1)B and C are present. So that is the nub we submit of the case, of our case. Because we say that therein lies the positive black letter law provision that requires, or that constrains the National Commissioner and the other actors, by the way, the Minister and the Board, from making, and this is precisely, sorry, let me just finish the sentence, please. Making a decision to grant medical parole absent that positive recommendation. This is the black letter law provision. Now, I've already dealt with why it's not, it must be applied. In terms of Odacrol, the making of regulations is ordinarily administrative action. So in terms of Odacrol and the principle of legality, this provision stands. But more importantly is the previous submission I made to you about this having the imprimatur of Parliament. And that indicates with respect that the legislative branch is satisfied that this accords with its legislative intent. And I'll take the submission no higher than that.
So just help me. How does one then reconcile 29A4 and 29.7 of the regulations?
29A4, just.
I think 29A4 is the one that Mr. Mpofu referred to as the double recommendation. So you've got both recommendations that are provided for in 29.4 of the regulation, and then another provision repeating or providing for a recommendation or referring to the recommendation of the board at 29.7. So at the end of the day, both recommendations are provided for in the regulation.
With the greatest of respect to my learned friend, that's a misreading. It's not a double recommendation.
Okay.
If I go to, if you have regard to 29 capital A3, and I've referred to this already, when an application for medical parole is received, and let's accept it's either in terms of 79(2)A, Roman 1 or 2, medical practitioner or someone else. When such an application is received, And we know 2C says that if it's not by a medical practitioner, it must be accompanied by a 2C report. So let's accept that. When you get such an application, then 29 capital A3 says, when the head of a correctional centre receives an application for medical parole, must refer the application to the correctional medical practitioner. I've already referred to that. Must make an evaluation of that application in accordance with the provisions of Section 79 and make a recommendation in this regard. Now, to who is that recommendation made? Not to the National Commission or the Minister.
Is that the correctional medical practitioner now that's provided? I can't find my regulations.
I'm terribly sorry, Justice. My learned friends are happy to. Can I hand up?
I would appreciate that because I've been looking and looking on my desk. I don't know. Thank you. Okay, just take me through again, Mr. Jenny.
If you have regard, Justice, to 29 capital A3, when the head of the correctional centre receives an application for medical parole, it must be referred to the correctional medical practitioner. And that is the
So strictly speaking, even though the the application was completed by a person who is a medical practitioner,
must still go.
If he was doing it on behalf of Mr. Zuma, then it would have had under this regulation 3, sub 3.
No. As we read regulation sub 3, regardless of whether it's by a medical practitioner or merely someone, because
that's what I'm saying.
There are two ways, Justice, as we understand Section 279(2). Let's accept that in the case of a Roman 1 application, a 2A Roman 1 application, there is a medical report because it's a medical practitioner. In the case of a Roman 2A Roman 2, let's accept there isn't a medical report, hence the need for a 2C report. That seems to be the way it's meant to work. It doesn't matter which route you get, which route or by which route you obtain the medical report. If you go to the regulations, in Regulation 29, capital A3, that application with a medical report will arrive at the head of the correction centre. Because obviously you can't have a medical parole application without a medical report of some other sort.
Okay.
So that will arrive at the head of the correction centre. That individual then refers it to the correctional centre's medical practitioner, who must evaluate it and make a recommendation in terms of 29A3. Now the important question is, who does that evaluation go to, or that recommendation go to? It doesn't go to the decision maker. It goes to the medical parole board. That's what 4 says. The recommendation must be submitted to the medical parole advisory board, who must make a recommendation to whom? To the decision maker.
Yeah.
So that's the structure of the regulations. And then we get, so there's no dissonance, there's no conflict between 4 and 7. Because what 7 does is give teeth to what and how the recommendation, firstly, what the nature of the exercise of the medical parole board's role is, and secondly, the effect of a non-recommendation. And what 7 says, and whether our learned friends like it or not, they've got to live with 7, because they haven't challenged it in this case or in any other case. They haven't questioned its constitutionality. So we submit that 7, sub 7, is a black letter legal provision that must be applied. I'll repeat, this court sua motu has no power to say, even if this court believes it to be unconstitutional, this court, or ultra vires, you cannot not apply it because it's there on the statute book and it's been approved by Parliament. But with the greatest of respect, we say it makes eminent sense to have a provision like 29A7 on the statute book or the subordinate legislation statute book for the following reason. The debate went around, and some of the justices put it to some of my learned friends. Mr. Fraser, we have his CV on record. He's clearly not a medical doctor. He has no medical expertise. So it doesn't behove our learned friends to say, well, in his reasons he says, I concluded that the provisions of section 79(1) were complied with. It doesn't, that's not worth the ink or the paper it's written on. It doesn't assist this court at all. Firstly, he doesn't explain how he got to that conclusion, and secondly, he doesn't have the expertise to reach that conclusion. And we've made this point both in our founding affidavit, our supplementary founding affidavit, and our heads of arguments. It makes perfect sense. It's a perfectly sensible and lawful, we submit, an appropriate division of labour for this very body that the legislature has seen fit to specifically bring into existence, to provide an independent report to determine the first of the three criteria for medical parole. And that is the matter dealt with in A. Because...
Can I just put something to you?
Certainly.
Let's assume that the board makes a recommendation that is just out to lunch. What does, and on your argument, the commissioner is bound to give effect to that recommendation. What does the commissioner do about it? If he is of the view that the board's recommendation is absolutely wrong, irrational, unreasonable.
Unreasonable, etc. I presume you could take it on review, Justice.
Take it on?
Review.
So he would have to set that aside mid-process, as it were.
The process is not complete.
Because he has to give effect to it. Unless he sets it aside.
Well, Justice Plaskett, it's not what I'm saying, it's what the regulation says.
Yeah.
The regulation makes it very clear. If it says, if the recommendation of the board is positive, then the National Commission, etc., must consider. So all that it's doing, and obviously you can put to me an out of left field example to test the proposition, but an out of left field example may be useful for testing the proposition, but it can't change the clear wording of this requirement. This requirement says, and ordinarily an expert body is not going to act out of left field and go totally off the rails. So the National Commissioner, when this body is set up, one can assume, we submit, that these are responsible, capable individuals who are put into a position. And any group of individuals can act rogue. You know, cabinet can go rogue and decide some crazy thing, but you can't operate a legal system on that basis. The cabinet may go rogue.
No, that's why I'm asking the question. What does the commissioner do when if they're faced with that particular problem?
It would be a hard question. The only answer I can think of, and I was asked a similar question in the municipal election case by now Chief Justice Zondo, about what if you know that the elections are going to be not free and fair. And it's always a question that, talking to the future, you don't know what the answer is or should be. But what I can say is that if the Commission is convinced that this decision, and again, it calls into question, how would you have the expertise to know that the decision is totally whack? But if he does know that it's totally whack, presumably he can give instructions to take it on review.
Yeah.
If he doesn't know that it's entirely wrong and irrational, he may give effect to it and then be successfully reviewed.
And in that process, does he totally ignore any other medical report that might be there?
He doesn't have the power, Justice Dambuza, on the clear wording of the regulation. He doesn't have the power. And remember, I spoke about a disinterested doctor earlier, medical reports. The fact of the matter is, the medical reports that are envisaged in Section 79, one of them, the 2C report, is at best, firstly, let me just perhaps unpack it a bit more slowly to make the point. Let's assume that a 2A Roman 1 application is accompanied or consists of a medical report. Right? I'm talking about the Act now, Joseph.
Yeah, I see.
if a section 79(2)A Roman 1 report, let's assume that it is accompanied by a medical report or it consists of a medical report, then the first thing you will note from this provision, section 79, is there's no indication of what the content of that report must be and what it must deal with and what it must set up. There's no indication. However, if we're talking about an application brought in terms of 2A Roman 2, then that is governed by B, which requires a report. And then C deals with the content of that report.
Right.
So in that scenario, you do have a report and we know what it must contain. But this report wouldn't be available to the Commissioner if it's an A1 application. Then you can have any sort of medical report, which doesn't necessarily comply with the standards and requirements of 2C. So you're dealing with reports that may or may not. If it's a medical practitioner, you won't have a 2C report. And on the contrary, if it's a Roman 2 scenario, you will have a 2C report. So the 2C report is not an essential. I don't know whether I'm making this submission
It's not an essential, I get you.
The 2C is not a sine qua non. Let me put it that way. Now, I apologize for using Latin as well. The 2C report is not a sine qua non for a valid medical parole application. That's point number one. Point number two is if you're not dealing with a 2C report, you're dealing with an implied 2A Roman 1 report as to which there's no legislative requirements as to what it must contain. Now, as opposed to those two unknowns, or not always presence, you have the 3A report, which is an independent report, flowing directly from a very deliberate decision by Parliament to introduce this independent body to provide an independent report for the guidance of the Commissioner.
But your bottom line is that when the board makes a recommendation, as a result of Regulation 29A7 in particular, the Commissioner is bound by it.
He or she is bound by it as a matter of black letter law, but as a question of interpretation of the section, before we even get to the regulation, I don't want to put all my eggs in the basket of the regulation. I'm saying, Justice Plaskett, on the purpose of interpretation of 79(3), and given the fact that Parliament has seen fit to interpose this independent body and its independent report that must be provided to the National Commission, etc., whoever the actor is, that report must be given centrality quite apart from the regulation, must be given, to answer Justice Mahoka's question, perhaps at very great length. It's not on a par with the 2C report and the 2A1 implied report. It has a higher status.
Mr. Jamie,
yes,
if I may ask, Regulation 29A5 enjoins the board to consider certain illnesses,
conditions and diseases.
Quite a number of things there. Infectious conditions, non-infectious conditions. I would imagine that must appear from their report.
That much?
That must appear from the report, whether they have considered this and whether this particular offender suffers from any of those. I don't see that in the board's report.
Well, Justice Mahoka, if you look at and I'm not a medical person, and I assume you're not either, but it divides it up into infectious conditions A and then B, non-infectious conditions. A lot of these things are not at issue in this case. So tetanus, severe head injury, liver cirrhosis, etc. And some of the things I can't pronounce. Lots of them are not at issue. But there is a catch-all. We know there's some reference to, I think, cardiac condition, etc., which I'm going to go to in the facts. But
no, I'm looking at the report by the board, CB 32.
Yes.
I'm not anywhere near being informed as to whether this was complied with.
No, Justice, can we just... you said CB?
CB 32.
32.
Unless I'm mistaken, but that's the report by the board, or the decision.
Well, firstly, Justice, this is a report, as contemplated in 79.3a. We would submit, and there's been no challenge to it as being such.
No, that might well be, but I'm just asking you whether there hadn't been a need to set out that which is pertinently taken in 5. I must be satisfied that they considered those that the regulation says they must consider. Where do I find that?
Justice Mahoka, with the greatest respect, I think we must all be very careful about, as laypersons from a medical point of view, seeking to interpret medical documents and medical...
No. I mean, it's not a question of being an expert. It's a question of the law. The law says the board must consider the following: whether the offender suffers from, for example, cardiac disease with multiple organ failure, diabetes mellitus with end organ failure, end-stage renal failure. Did they consider all this?
Sorry, Justice Mahoka, in order to run through this veritable list of dread diseases and conditions, it cannot reasonably be expected, and that's no one's case, no one suggested that as a case, or as an allegation of fact and or law in this matter, that in every case, the medical parole board must consider each and every one of these conditions.
Not each one of them, but based on the report. Remember, the board considers the reports of others.
The board considers the reports of others, and
yes.
it makes the conclusion very clearly.
For example, the report of others, for example, say Dr. Mafe says, he suffers from, let's pick up one, cardiac disease with multiple organ failure. Say that's what Dr. Mafa says.
Yes.
Isn't the board supposed to comment on that in its report?
It has commented on it.
It has commented.
It has commented on it. It said the board appreciates the assistance of all specialists. And I'm now dealing with an aspect that hasn't been raised by any of the parties, Justice, but I'll deal with it. The board appreciates the assistance from all specialists with provision of the requested reports. From the information received, the applicant suffers from multiple comorbidities, etc., and it goes on. So quite clearly, the board has looked at all the reports and reaches this conclusion. The fact that the conclusion may be terse doesn't render it not a report for purposes and compliance, and no one has suggested that the board did not.
You would agree with me that the board could have done better?
I may agree with that proposition, Justice, but it, with the greatest of respect, doesn't have any legal consequences. There is no legal challenge.
No, but it goes to the rationality of the commissioner's decision. Because the commissioner says, I have reports, at least 2 reports, by 2 doctors who examined Mr. Zuma and found him to be eligible for parole.
No, but...
He says, look, I looked at that,
I'm sorry.
and he could be wrong, but is that unreasonable? Is that irrational?
It was irrational, it was also unlawful, and he had no power to act. Can I explain to you why, Justice Mahoka? Can we go to the reports that you are referring to? And let's begin with the addendum to the application, which we now know was filled out by Dr. Mafa. If you go to CB11 and go to the bottom, and Justice Bukwana put this to my learned friend, one of my learned friends. In respect of question D, is the offender suffering from a terminal disease or condition? Now, there was some debate, but if Mr. Mpofu and I agree on one thing in this case, it is that disease and condition are used interchangeably. That much is also apparent, if I can just go quickly to the regulations. The regulations themselves use disease and condition interchangeably. So, sorry. My learned friend says the Act as well. I haven't looked at that. But if you go to B of 29A, it says non-infectious conditions. And then under the list of non-infectious conditions, they list, for instance, in Roman 2, ischemic heart disease, Roman 3, chronic obstructive airway disease, Roman 5, cardiac disease, Roman 14, neurological sequelae of infectious diseases with a Canopsky score of 30% and less, and then 17 constitutes a terminal disease or condition or is incapacitated as a result of injury, disease, or illness. So it seems, for the purpose of this scheme, they used interchangeably. So, accepting that, the question is the offender suffering, back to CB11, from a terminal disease or condition, which is chronic? The answer is yes. Is progressive? Yes. Now, that seems to be the bedrock of the submission by both my learned friends, that there's a positive assertion that the patient, Mr. Zuma, is suffering from terminal disease. But with respect, Justice Bokwana was quite correct to point out to them that it doesn't stop there, it goes on. Because these are conjunctive, this is a conjunctive three-part question. It goes on to say, has deteriorated permanently or reached an irreversible state. Now, to all of us as laypersons, if someone says someone is terminally ill, we all shudder, we all have a very good idea of what that means. It generally means, as the department itself accepts in this form, in the definition they give, it means imminent or even lingering, which is worse, death. And all you can offer, you cannot cure the person any longer. That's the crux, and that is what a terminal disease is. It cannot be cured. It's not merely a chronic disease. You can suffer from chronic rheumatoid arthritis for years. It's chronic, but it's not going to kill you. But a terminal disease is something that's going to kill you. It may take a little longer, but it will kill you. And that is precisely
if a person suffers a combination of diseases,
yes,
and they may as well kill that person in the next week.
I'm sorry, Justice.
A combination of those diseases may as well kill a person in the next week or 2 weeks.
Yes.
Another one suffers a terminal illness.
Sorry, what illness?
Another one suffers a terminal illness.
Terminal illness, yes.
Might die in a year or so.
Yeah.
Which one must be released on parole?
That's not a question, happily, that I have to answer or the court has to answer. Provided happily, that's not a question I have to answer or the court has to answer.
Yeah.
The only question is it terminal in accordance with medical diagnosis? And if it is, then that qualifies for medical
that goes to the interpretation of the word terminal. Do we give it a narrow interpretation? Do we give it a broader interpretation?
We give it the interpretation. We are happy, and we say so in our papers, we're happy to go with the department's own interpretation, understanding of what terminal is. We don't have to cross swords. We don't cross swords with them. We're happy to go with them. So let's see how they interpret it. And not only in terms of this document, let's see how they interpret it in terms of their own policy.
Yes.
So can I go there? At CB11, a terminal disease or condition, understood as properly read, a terminal disease or terminal condition, right? The word terminal applies to both. A terminal disease or condition is a conditional illness which is irreversible with poor prognosis and irremediable by available medical treatment, but requires continuous palliative care and will lead to imminent death within a reasonable time. That, with respect from my layperson's perspective, is as good a description of terminal disease or condition as you're probably going to get. And that is how the department, in its own documentation, puts it. That's the guidance for the person filling out this form. That is what we mean when we say, when we ask you the question, is the offender suffering from a terminal disease or condition? That's what we mean. Does he fall within this? I mean, that's the only way to read this, the only logical way to read it, right? But now, you don't have to stop there, because there's a policy which forms part of the core bundle.
Perhaps before you get to the policy,
Certainly, Justice.
Your submission is that if the answer given to that third component of the question was yes,
then we would have had.
Then that would be a clear indication that in fact that's the diagnosis. Not
Had
so.
Dr. Martha answered yes to the third component, I'm sorry, I jumped ahead to the policy. You're quite correct, Justice. Because our submission is made in the papers, our affidavits, not only our hands, is that in answer to that crucial question, has the disease or condition deteriorated permanently or reached an irreversible state, which is the axiomatic part of terminal disease. It must be irreversible. It's terminal. Had the answer been yes, yes.
Okay.
But the
Mr.
answer
Jamie,
is
can we take a 10-minute break, please?
Certainly, Justice. Sorry, can I just finish the submission? The answer is deteriorated significantly, not yes.
You're going to have to say that again.
Exactly.